Hello, Christopher. All right. Getting myself situated here. I literally just got home 10 minutes ago. Been out of town for the last day doing a event. Um Half work, half play. So, and of course, knew that this filing would have to happen when I was gone. And I delayed even leaving yesterday, trying to make it so I would be able to do the live as soon as the filing happened. Hello, Sherry and Millbilly and Sup Cat. Um, so I was hoping the filing would be out early enough that I would be able to hello Autumn um before I left. Didn't happen. And so I was literally at a political brunch in today when I get an email from Kathleen giving me her filing. So I've been at political stuff until now. I just drove forever home. So I have not read this filing. So me reading it aloud to you all will be the first time I am looking at this. So you may have already read through it, so you're going to know things that I don't. So you're just going to have to bear with me as I go through this. Um it took you almost 2 hours to read it. Yay, cuz that's just what I want. It's 7:30 p.m. my time now, and I'm on 5 hours sleep, and yeah. Okay. So we'll see how long this takes me to get through it. For those that don't know, who am I? My name is Jax West. I am no relation to Steven Avery or the family. I'm just like everybody else here. Your people who watched Making a Murderer and got interested in the case. And so we've got a Facebook page and group called Steven Avery Project. Then we have a subgroup that is called MAM Gossip, which MAM, because sometimes people don't realize it stands for Making a Murderer. And then we also have um, the Justice with Jax page and group. And Justice with Jax is then where I can talk about any case, not just Steven Avery. So, when I'm reading this, if you have questions, I've got a second screen here, and I'm not sophisticated like all these YouTubers, Millbilly, that I'm going to be sharing a screen with you or doing any fancy stuff. It is just me reading this off of my second screen. So if you ask a question, I may not see it. So don't think I'm ignoring you. I may not see it, so you may have to answer it or ask it again. Or Millbilly, since you've already read through this and are very familiar with all things on this case, Millbilly can answer you, or anybody else that's on here if you can answer. So just know if I don't answer it, I'm also reading this. I may not see your question. Um all right. So let's get into this. Also, so Christopher is on here. Christopher is a moderator for all of my pages. So he will be keeping an eye on the comments that go here. If he is able to answer a question, he will. And also if anybody misbehaves, Christopher is here to take care of that. So I won't see it. Just know whether you're watching this live or you're watching this later, Justice with Jack, Steven Avery project. We are 100% believe in Steven, or not just believe, no, Steven is innocent. This is not a debate forum here on what guilt or innocence. So if you come here and you post anything saying anything about guilt, we're going to just delete your message and you're going to get booted. And for you to know, here on YouTube as well as our Facebook pages, I don't tolerate bullies and attacking people. So there's lots of stuff to critique in the case and the players in the case. I want you to be respectful to each other and don't be attacking other posters. So that's another way to get yourself booted, timed out, muted, whatever. So behave to each other. And if it's a guilter, Christopher's going to take care of it. And they're just going to, there's no reason to debate a guilter. But if you see a guilter post and we don't catch it, flag it, whether it's here or on Facebook. Let us, because we might not see that when a new filing happens, we get so much traffic to all the pages. I can't remember the number that Christopher told me that we've had now in 24 hours on Steven Avery project. Of just going insane. So flag it. So most likely Christopher will see it and can be and take care of any guilters. And if you're bullying, we're going to come at you for that. Tauntaun is asking, do you know how Steven and Brendan are doing? I always say with Steven and Brendan, it's, they want to go home. And so that's the pretty standard. I know Steven's been impatient of wanting this filing to happen. So now that it has happened, hopefully he's feeling better. And as I read this, I may get a better idea of that. And Kat has pointed out, because I'm not one of these, I'm not a professional YouTuber or whatever. So it's like, yes, please remember to hit like and subscribe or so on. And then maybe you'll get notified of when I go live here. I'm going to start by reading, and Christopher, if you can post in here, or Millbilly, whoever has it, fast, because I'm reading it from the email that Kathleen sent me. So if somebody can post in here the link to Kathleen's website where you can also read this up for yourself. So y'all have that. So I'm starting. Oh, and just so you know, if I say, because some people get bothered by this, if I say blah, 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 it's because a lot of these will have case numbers or whatever, these long, I'm not going to read you a case number. I'm just going to say blah, blah, blah. Don't get offended. Not a lawyer. Don't pretend to be a lawyer. When they're citing case law and those kinds of things, if it's not directly pertaining to Steven's case, I'm skipping it. So you have the link. You can go read it for yourself if you want to go read when they're going to talk about a past case, that kind of stuff. We're going to jump over that. All right. So evidence supporting Mr. Avery's third, blah, 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 because it's 974.06. See, I'm not going to read that number all the time. Mr. Avery's third post-conviction motion. 1. Newly discovered evidence. New witness provides direct connection between Bobby and the Hallbach murder. Christopher posted yesterday, I can't remember what website it was or whatever, but Christopher had posted the links to it where the place wouldn't say Bobby's name. Because they're like, well, they haven't been whatever, and so we're not going to use his name. Because Christopher let me know that was happening. So Bobby, as I always go, Bobby, the killer. Because all the evidence points to Bobby. I'm an evidence and facts person. Um, so everything is pointing to Bobby. All right. So newly discovered evidence, new witness provides direct connection between Bobby and the Halbach murder. And then it says underneath that, 1, the Sawinski report was discovered after Mr. Avery's conviction. And I'm going to wait until we get to that part. These are just the titles. So I'm not going to, cuz I fall down rabbit holes and you're going to have to follow along with me as squirrel. I'm going to get distracted and go into stuff. 2, Mr. Avery was not negligent in seeking the evidence. Oh God, I hate when they say that he's negligent. 3, the evidence is material to an issue in Mr. Avery's case. Applicable law regarding Denny. The Denny requirements are now satisfied. A, Bobby's, the killer's, motive to commit the murder of Teresa Halbach. B, Bobby's, the killer's, opportunity to commit the murder of Teresa Halbach. C, Bobby's, the killer's, access to items of evidence to frame Mr. Avery. D, Bobby had access to Mr. Avery's blood. E, Bobby's direct link to the murder of Ms. Halbach. 4, the evidence is not cumulative. Reasonable doubt as to Mr. Avery's guilt. And then section 2 is Brady violation regarding the Sawinski evidence. And then applicable law regarding Brady. Mr. Avery is not procedurally barred from raising his Brady claim. Section 3, a second Brady violation regarding Halbach's RAV4. Mr. Avery is not procedurally barred from raising his Brady claim. In the alternative, Mr. Avery is entitled to a new trial in the interest of justice pursuant to blah, blah, blah. An evidentiary hearing is required. And conclusion. Here's table of contents of all these cases. Skip. Notice of motion and third motion for post-conviction relief pursuant to Wisconsin statute blah blahs. Please take notice that the petitioner, Steven A. Avery, by and through his current post-conviction attorneys, Kathleen T. Zellner and Associates, respectfully moves this court pursuant to Wisconsin statute blah blah for an order vacating the judgment of his convictions and sentence and ordering a new trial. In the alternative, he asks that this court grant a new trial in the interests of justice pursuant to Wisconsin statute blah blah or its inherent authority because the real controversy was not fully tried. In support of his motion, Mr. Avery states as follows. Mr. Avery requests an evidentiary hearing and that he be produced for that hearing. I always hate when people go to court and you don't get to be there. This is your life. I don't care what it costs to transport. I don't care about the security that they have to do or whatever. You should be able to be in court. Introduction. 2 new witnesses have emerged in Mr. Avery's case with new and compelling evidence about a murder mystery that has intrigued a worldwide audience. The rush to judgment and tunnel vision that led to the arrest, prosecution, and conviction of Mr. Avery is exposed by these new witnesses who provide new and undisputed evidence that directly links Bobby Dassey, and then she's got in quotes Bobby, but it should just say the killer, to the murder of Teresa Halbach and the framing of Mr. Avery. Furthermore, this new evidence allows for a reconsideration of the real motive of this crime as being a sexual homicide, which was the culmination of an obsession by Bobby, the killer, with viewing thousands of images of violent, deviant pornography. On October 31, 2005, the obsessive fantasies of Bobby became a horrible reality when Teresa Halbach was brutally assaulted and murdered by 2 rifle shots to her skull. Her body was mutilated, as were many of the female subjects in the Dassey computer images. Should say the Bobby Dassey computer images. Bobby was in possession of the Halbach vehicle, which contained the crucial evidence of this terrible crime. Ms. Halbach's blood, key, electronic devices, and license plate, which was concealed in another salvage car, and Mr. Avery's carefully deposited blood on the seats and dash and DNA on the hood latch. By being in possession of the vehicle, Bobby was able to control the direction of the investigation. He planted the vehicle on the Avery property after he deposited Mr. Avery's blood and DNA in it. He had Ms. Halbach's key and electronic devices, which ended up in Mr. Avery's bedroom and burn barrel. Bobby, my killer, did all of this to exculpate himself and to frame his uncle, Mr. Avery. Mr. Avery does not have to prove who committed this terrible crime to receive relief. This is not his intent or purpose. However, he does have a right to prove he did not receive a fair trial. The new evidence, which establishes that Bobby meets all of the Denny criteria to be a third party suspect, and the evidence of 2 Brady violations, demonstrate that Mr. Avery was deprived of a constitutionally guaranteed right to present a complete defense to the charges against him. And now it's citing other cases. Statement of the case. 1. The case began in early November 2005 with the disappearance of Teresa Halbach, a 25. Oh, I guess that's when they started searching for her, right? Because I'm like November. A 25-year-old professional photographer. Ms. Halbach was reported missing on November 3rd, 2005. Okay, I'm not. I was about to say something, but maybe I shouldn't say that. Volunteer searchers found Ms. Halbach's Toyota RAV4 on the 40-acre site of Avery's Auto Salvage, a salvage yard business where Mr. Avery and other family members lived and worked on November 5, 2005. Ms. Halbach had photographed vehicles at the site previously, per Mr. Avery's request. According to state witness Bobby, the killer, Ms. Halbach was last seen walking towards Mr. Avery's trailer on October 31, 2005. 2. After finding Ms. Halbach's RAV4, law enforcement searched the Avery property and, over the course of the next 4 months, discovered and identified evidence including burned bone fragments in and around a burn pit, with DNA matching Ms. Halbach's. Didn't it never match Teresa Halbach? They said it was her mother. The DNA was consistent with her mother in the female line, correct? Michael Ryan's here. Isn't that correct though? That it was never. It's never been 100% that was Teresa. Any of those bones are Teresa Halbach. That they tested it, and it's along the lines of her mother. Doesn't mean it wouldn't be Teresa, but just there's no proof that it was Teresa. And I am not a conspiracy theorist, no tinfoil hat on me. But there's been nothing that's proven. All we know is Teresa Halbach has allegedly not been seen or heard from. I don't believe she's alive, but those we don't know those are her bones. And we don't know, so you don't know if she's been shot. Nothing. Okay, anyway, where was I? I need to remember to put my little cursor where when I go off into okay, with DNA matching Ms. Halbach's. No. Mr. Avery's and Ms. Halbach's blood in the RAV4, the remnants of electronic devices and a camera, the same models as Ms. Halbach's in a burn barrel, Ms. Halbach's RAV4 key in Mr. Avery's bedroom with Mr. Avery's DNA on it. What a crock of shit that is. Mr. Avery's DNA on the hood latch. Sweat DNA of the RAV4 deposited, the state later claimed by, oh, here it is, by Mr. Avery's sweaty hands. No such thing as sweat DNA. And a bullet in Mr. Avery's garage containing Ms. Halbach's DNA, which you brought a chapstick in dirty underwear from her house to Stevens. Why is evidence going from Teresa Halbach's house to Stevens? Why isn't it going directly to a lab? Another thing is they took Stevens Grand Am and literally had it parked in their garage, the police garage or sheriff department's garage or whatever, and the lab tech was going in between the RAV4 and Stevens Grand Am and didn't change gloves. So how can you say anything of Stevens being on a door handle of any kind that Steven deposited there and it wasn't from their lab tech? All right. Procedural history. Section 1, third-party suspects. On July 10, 2006, before Mr. Avery's trial, the trial court entered an order entitled, quote, Order regarding state's motion prohibiting evidence of third-party liability, unquote, which then it also has in parentheses, Denny motion. The order specified that if the defendant intended to suggest that a third party other than Brendan Dassey is responsible for any of the crimes charged, the defendant must notify the court and the state, unquote, of such intention at least 30 days prior to the start of the trial. The trial court further ordered that the defendant would be subject to the standards relating to the admissibility of any third-party liability evidence pursuant to State versus Denny, which again, bullshit. Are you really trying to find justice? Are you really trying to find who really did this crime and that you're trying to get them off the street? No, we're trying to block Steven from being able to provide a defense. That there are other people that should be looked at. No, let's do everything to stop facts. Next page. We're on page 9 of 149. 4. In light of the court's order on January 10, 2007, Mr. Avery filed the, quote, defendant's statement on third-party responsibility, unquote. There, Mr. Avery stated that he did not kill Ms. Halbach and that there was, quote, at least a reasonable possibility that one or more unknown others present at or near the Avery salvage yard on the afternoon of October 31, 2005, killed her, unquote. Mr. Avery identified several persons as potential alternative perpetrators. Scott Taddock, who has a very long record and also helped Bobby Dassey, Andre Martinez, Robert Fabian, Charles and Earl Avery. Charles and Earl Avery have done so many. They've got a long list of things that they've done, especially assaulting women. And the Dassey brothers. Mr. Avery argued that Denny did not apply to the circumstances in his case, and that as a result, he should not be bound by the three-party test set forth in Denny. He further argued that even if Denny did apply to his case, he should be permitted to introduce evidence at his trial of several alternative perpetrators in this case. So this alleged crime happened at a working business. So you have the people who live there, you have the people who work there, you have the customers who show up there. There's so many different possibilities. Um, so Robert Fabian, who was Earl's brother-in-law at that time, they're riding around in a golf cart together, shooting at things. Earl assaulted a wife. Earl put camera in his bathroom so he can watch his stepdaughter and daughters and their friends change into bathing suits. Um, Chuck assaulted a wife, raped family members, allegedly. No, you don't want to look at any of these people? Okay, then. Five. On January 30, 2007, the trial court entered its quote decision and order on admissibility of third-party liability evidence, unquote. The court held that Denny's quote legitimate tendency, unquote, test applies to any evidence the defendant wished to present regarding potential third parties who might have been responsible for Ms. Halbach's murder. The trial court found that, quote, in the absence of motive, it certainly may be more difficult for the defendant to offer evidence which is relevant and material connecting a third person to the crime. The court simply finds nothing in the offer made by the defendant that goes beyond the level of speculation, unquote. And then the footnote at the bottom of the page says citations to the record on appeal appear with the document number. Oh, we don't need to read that. All right, next page. 2, verdict. Number 6, on March 18, 2007, Mr. Avery was convicted following a jury trial of first-degree intentional homicide, contrary to Wisconsin statute, blah, blah, and felon in possession of a firearm, contrary to Wisconsin statute, blah, blah. The jury found Mr. Avery not guilty of mutilation of a corpse. Let me dig into this, the firearm possession. So Steven was considered a felon due to back during the whole Penny Bernstein thing, or the thing before Penny Bernstein with his cousin, what's her name? Sandra Morris, when he chased her down and then pointed a gun at her, is that so now he's a felon, so he cannot be in possession of a firearm. All right. But now, in the 2 years that he was free after serving 18 years for a crime he didn't commit that he was framed for, he was able to get a hunting license. And then the gun, so that Glenn Marlin, I can't remember, rifle, it was hanging over Steven's bed. The thing, people, if you haven't done the going down the rabbit hole and looked into everything about this case, that you may not realize is the trailer that Steven lived in did not belong to him or the Averys, nor did the land it was on or the garage. None of that is Avery property. That was sold to Raleigh Johnson by Alan Avery. Raleigh Johnson was a friend of Alan's, and Raleigh needed a place to put his hunting trailer. And so Alan had sold that to Raleigh. And so almost everything in that trailer that Steven and Jody lived in belonged to Raleigh. Jody, when she moved in, the only things furniture-wise or whatever that Jody brought in there was a bed and a desk. So that gun that was hanging in the bedroom was Raleigh's. That Raleigh even testifies that he would shoot it all around the property. Now, I'm doing a technicality thing of that you're a felon, you can't have this gun. So it doesn't matter that he's living in Raleigh's property and this is all Raleigh's stuff. You can't have that gun there. But it's still just a bunch. So Steven Avery would have been doing time no matter what happened with the Teresa Halbach thing. He would have been doing time for that gun because he's a felon from the Sandra Morris thing. So, so I don't know what the legalities on that is on how much time he would get for that for eventually, hopefully, knock on wood, when he's able to sue for this wrongful conviction, on how if you're doing math by how many times he's in prison that he shouldn't be, and what he would have gotten for having that gun and being a felon. But it is a question of, why is he able to get a hunting license then if he's a felon and can't have a gun? Be consistent. 3, post-conviction and direct appeal. Number 7, on June 29, 2009, prior post-conviction counsel filed a motion for post-conviction relief on Mr. Avery's behalf pursuant to blah, 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 seeking a new trial on grounds that 1, the trial court improperly excused a deliberating juror, Richard Mahler, and 2, the trial court improperly excluded evidence of third-party liability. Number 8, on January 25, 2010, the motion for post-conviction relief was denied by the Honorable, I hate that they have to put honorable, Patrick L. Willis in a written order. Regarding the issue of Bobby's third-party liability, Judge Willis found, quote, the only evidence offered by the defendant to show motive on the part of Bobby Dassey consisted of evidence allegedly supporting a motive to frame Steven Avery. No evidence is offered to suggest Bobby Dassey had a motive to murder Teresa Halbach, unquote. Let me finish reading before I go off. Judge Willis concluded, quote, the evidence offered against Bobby Dassey probably did meet the opportunity and direct connection to the crime requirements of the legitimate tendency test because of his presence on the property at the time Teresa Halbach was there. However, without any showing of motive, third-party evidence against Bobby Dassey is precluded under Denny, unquote. What's Steven's motive? So you're saying Bobby has no motive. What's Steven's motive? And prove Steven's motive. Because they searched his house looking for porn. Searched his computer. Oh, so they found a video of Steven with Jody. That's not deviant. How many of you have made those videos? That's not deviant behavior. Pink furry handcuffs. Barb had those same handcuffs. Having sex toys does not mean you're a deviant. What's his motive? Because there's nothing in Steven's past. So that's a bunch of bullshit that you don't have to prove a motive for these other suspects, but you have no motive for Steven and you can prosecute him. Steven was free after serving 18 years of a crime he didn't do. He had a girlfriend that he was in love with. He was about to get 200,000 from the state, and his $36 million lawsuit was in depositions, and he absolutely was going to be getting money. How much? Don't know. But he was about to come into a lot of money. And you're going to go, now I'm going to kill some random girl when there is nothing in his background? Don't tell me about the smurfing cat. Steven didn't do the cat. Steven got and took the blame for the cat. Steven was there. Steven did nothing to stop it. Not cool. I don't like it. Doesn't mean he's raping and killing a woman. There's no motive. Nothing. 9. On December 14th, 2011, the Wisconsin Supreme Court denied Mr. Avery's petition for review pursuant to blah, blah. Number 10. On February 14, 2013, Mr. Avery filed his first and only pro se collateral post-conviction motion pursuant to Wisconsin statute, blah, blah. The motion was denied by the dishonorable, I added the dis, not Kathleen, so don't try calling her out for that, dishonorable Judge Angela Suckowitz Flowers on November 23, 2015. Number 11, on October 11, 2019, current post-conviction counsel appealed the circuit court's denial of Mr. Avery's second post-conviction motion and all of its supplements. He filed motions to stay and remand concerning 2 additional claims. At the appellate court's direction, Mr. Avery raised his claims in his motions to the circuit court as supplemental post-conviction motions. The circuit court denied his motions to supplement. On April 12, 2021, Mr. Avery filed a motion to stay and remand, and the appellate court denied it. Section 4, the appellate court's July 28, 2021 decision. Number 12, on July 28, 2021, the appellate court issued a per curiam, or however you say that, opinion upholding the circuit court's summary denial of Mr. Avery's claims raised in his post-conviction motion and 2 supplemental motions, holding, quote, Avery's motions are insufficient on their face to entitle him to a hearing, unquote. 5. Petition for review. On November 17, 2021, the Wisconsin Supreme Court denied Mr. Avery's petition for review. 6. The appellate court reserved Mr. Avery's ability to file a successive blah blah motion on certain claims. On April 12, 2021, during the pendency of Mr. Avery's appeal, Mr. Avery filed a motion with the appellate court to stay his appeal and remand for evaluation of a new claim. The appellate court acknowledged this claim, stating the following. On November 9, 2020, we notified the parties that this case had been submitted to the court for decision on briefs. On April 12, 2021, Avery filed another motion with this court to stay his appeal and remand for evaluation of a new claim. This claim concerns an alleged Brady violation, the factual basis for which Mr. Avery obtained on April 11, 2021. Specifically, the claim is based on the affidavit of Thomas Sowinski, a Manitowoc motor route driver, never heard it described like that, who attests that days after Ms. Halbach's death, while on his paper route in the early morning hours, he spotted a shirtless Bobby Dassey and an unidentified older man pushing Ms. Halbach's vehicle down Avery Road towards the junkyard. Mr. Sawinski further attested that after he delivered the paper, Bobby Dassey attempted to block his exit, causing him to swerve and drive into a shallow ditch, which I love that Carla tried to claim that there isn't a ditch there, and there absolutely is. Mr. Sawinski claimed to have called the Manitowoc Sheriff's Office later that day to report what he had seen, but was told they, quote, already know who did it, unquote. He also claims to have attempted to contact Avery's trial attorneys after season 1 of Making a Murderer, but never heard back from them. And there's a footnote on that, so let me go down to that at the bottom. The footnote says Mr. Avery's current post conviction counsel has investigated the matter further to learn that Mr. Sawinski did not contact Mr. Avery's trial attorneys as he originally believed and stated in his original affidavit, but rather that he emailed the Innocence Project in 2016 after watching Making a Murderer season 1. His email was never passed along to any of Mr. Avery's attorneys. Mr. Sawinski's first attempt to contact Mr. Avery's current post conviction attorneys was in December of 2020 after Mr. Avery filed his second post conviction motion in 2017. Further, Mr. Sawinski's memory was refreshed with a recorded dispatch that was recently discovered, in that he made the call to the Manitowoc Sheriff's Office on November 6, 2005. Dun dun dun. When else was there a call made that nobody did anything with? Would that be Mr. Andrew Colborn, who was called at the jail and told they have the wrong person and nothing gets filed until after Making a Murderer comes out? Yeah. All right. Further, in its July 28, 2021 opinion, the appellate court advised when Avery filed this motion, we had already twice stayed his appeal, each time because he asserted that the new claims related to this previously litigated and that it would be most expeditious. When you have a lisp, expeditious is a hard word to say. Most expeditious to resolve them as part of the instant appeal. By the time Avery filed this new motion, however, we had already evaluated the legal and factual basis for claims already raised. We therefore were and are in the position to conclude that this newly raised Brady claim bears little or no relation to those claims already before us. This is instead a distinct issue that the circuit court should resolve on a standalone basis through a new Wisconsin statute motion. Avery's latest motion arrived while our decision on his appeal was forthcoming. It would be an inefficient use of court resources to now, and once again, delay this appeal's resolution. We appreciate that Avery likely wishes us to consider this new Brady claim in the context of claims previously raised, but we must weigh that implicit consideration against those discussed above. Simply put, Avery's appeal cannot continue indefinitely. Accordingly, this decision operates as an order denying Avery's April 12, 2021 motion to stay and remand. If Avery wishes to raise this claim, he must file a new Wisconsin statute blah blah motion with the circuit court. Okay. The appellate court reserved Mr. Avery's ability to file a successive motion on the claim in his most recent filing concerning the new witness who came forth on April 11, 2021. Specifically, the appellate court instructed the following. As discussed below, we are not addressing Avery's most recent filing to this court. See our discussion of motion number 6, which claims to directly connect Dassey to Halbach's murder. If Avery wishes to raise that claim, he will need to bring a new Wisconsin statute motion. That motion would need to survive both Escalona Naranjo, another case, scrutiny, and be found to have merit. In which case, and this is underlined, this section, the evidence presented might supply the missing direct connection. Done being underlined. In that event, the Veli, did I say, I always forget if it's Veli CD, might become irrelevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect. We express no opinion on the merit of any such motion, as all such issues would be for the circuit court to decide in the first instance. Regarding certain claims Mr. Avery raised in his motion to reconsider the circuit court's October 3rd, 2017 order denying his second post-conviction motion and its two supplements, the appellate court found that, quote, neither we nor the circuit court have squarely considered whether these claims are procedurally barred under Escalona Naranjo or whether Avery pled sufficient materials entitling him to a hearing. Such consideration would have to come on a separately filed Wisconsin statute motion, and we express no opinion as to whether such claims would be barred in the event such a motion is filed, unquote. Thus, the new material that Mr. Avery raised in his motion to reconsider and its supplements was never ruled upon by the circuit court. Next section is titled Evidence Supporting Mr. Avery's Third Blah Blah Post-Conviction Motion. 1. Newly discovered evidence. New witness provides direct connection between Bobby and the Halbach murder and planting evidence to frame Mr. Avery. Mr. Avery's new witness, Mr. Thomas Sawinski, contacted Mr. Avery's current post-conviction counsel in December of 2020. Mr. Avery had already filed his appeal on October 11, 2019. Mr. Sawinski stated that he had witnessed Bobby, the killer, and one other individual, a bearded man, pushing Ms. Halbach's RAV4 onto the Avery salvage yard in the early morning hours of November 5, 2005. Mr. Sawinski claimed that he had reported this information to the Manitowoc Sheriff's Office. On April 11, 2021, Mr. Sawinski provided an affidavit to Mr. Avery's current post-conviction counsel, stating the following, quote, Mr. Sawinski was a motor route driver. I just never heard it called a motor route driver. He was a paper guy for Gannett Newspapers, Inc., and delivered papers to the Avery salvage yard in the early morning hours of November 5th of 2005. Prior to delivering the newspapers to the Avery salvage yard, he turned onto the Avery property and witnessed two individuals, a shirtless Bobby Dassey, and now remember, this is November, and he's shirtless in Wisconsin, a shirtless Bobby Dassey, and an unidentified older male suspiciously pushing a dark blue RAV4 down Avery Road towards the junkyard. The RAV4 did not have its lights on. Mr. Sawinski drove past the two men and delivered newspapers to the Avery mailbox. And then he turned around and drove back towards the exit. When he reached the RAV4 still over there, Bobby Dassey attempted to step in front of his car to block him from leaving the property. Mr. Sawinski came within 5 feet of Bobby Dassey, and his headlights were on Bobby during this entire time. Then Sawinski swerved into a shallow ditch to escape Bobby and exit the property. Mr. Sawinski states in his affidavit that he called out, quote, "Paper boy, gotta go," unquote, because he was afraid for his safety. He further stated that Bobby Dassey looked him in the eye and did not appear happy to see Mr. Sawinski there. After Mr. Sawinski learned that Teresa Halbach's car was found later in the day on November 5, 2005, he realized the significance of what he had observed and immediately contacted the Manitowoc Sheriff's Office, unquote. The following day, April 12, 2021, Mr. Avery filed a motion for remand and stay of appeal to the appellate court containing Mr. Sawinski's original affidavit. And the footnote on this page says throughout this motion, the information Sawinski provided will be referred to as, quote, the Sawinski evidence, unquote, which is contained in two affidavits cited throughout this motion as Exhibit F and Exhibit 1 to Mr. Avery's motion for remand and stay of appeal. Sorry, I have degenerative disc disease. So my back is really stupid, and it was a long day and driving for 5 hours. So now I'm going to start getting real as my back hurts. I'm going to be getting more and more fidgety. Sorry. Um the Sawinski evidence provided by Mr. Sawinski to Mr. Avery's current post-conviction counsel is newly discovered evidence which provides the missing direct connection between Bobby and Ms. Halbach's murder, making him a Denny suspect. The discovery of new evidence may constitute a sufficient reason for a second or subsequent post-conviction proceeding under Wisconsin statute, blah, blah, citing other cases, da, 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 da. To prevail, however, the movement must carry the burden of proving that the evidence at issue is newly discovered. In most cases, to obtain relief based on newly discovered evidence, a convicted person must establish by clear and convincing evidence that 1. The evidence was discovered after conviction. 2. The defendant was not negligent in seeking evidence. 3. The evidence is material to an issue in the case. And 4. The evidence is not merely cumulative. State versus blah, 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 their case. If the person satisfies those 4 requirements, then the circuit court must determine whether a reasonable probability exists that a different result would be reached in a new trial. Next section is titled The Sawinski Evidence Was Discovered After Mr. Avery's Conviction. Mr. Avery did not have the Sawinski evidence before Mr. Sawinski came forward to Mr. Avery's current post-conviction counsel in April of 2021. Mr. Sawinski attempted to contact the Innocence Project and not Mr. Avery's trial defense counsel via email in 2016 regarding the evidence he had, to no avail, and had not previously provided it to Mr. Avery's counsel. Rather, the Sawinski evidence was reported to the Manitowoc Sheriff's Office by Mr. Sawinski, but the evidence was suppressed from Mr. Avery by the prosecution. Next section is titled, Mr. Avery was not negligent in seeking the evidence. Neither Mr. Avery nor his counsel were on notice that Mr. Sawinski had any knowledge about Bobby's actions on November 5, 2005. That's citing another case. Okay. Next section. The evidence is material to an issue in Mr. Avery's case. The Sawinski evidence is material to several issues in Mr. Avery's case. Most importantly, it is material for establishing Mr. Avery's defense. That is, that a third party committed the crime against Ms. Halbach. It is material for establishing the direct link to Bobby as a third party Denny suspect and opening the door to reconsidering the Veli CD as establishing a sexual motive for the murder. Additionally, the Sawinski evidence is material to the evidence in the RAV4 being planted by Bobby, including Mr. Avery's blood and DNA. The RAV4 also contained the Halbach vehicle key and Ms. Halbach's electronic devices, which were discovered in Mr. Avery's bedroom and burn barrel, respectively. Further, the Sawinski evidence is material to impeach Bobby's trial testimony that Ms. Halbach never left the Avery property and that she was last seen walking towards Mr. Avery's trailer. Bobby was the state's primary witness against Mr. Avery. During his opening statement, prosecutor Sweat Kratz explicitly informed the jury of the significance of Bobby's putative. I think that says putative. I don't know that word. Observations on the date of Ms. Halbach's disappearance. To hear that Bobby Dassey was the last person, the last citizen that will have seen Teresa Halbach alive. Unquote. Bobby's testimony was the most determinative of Mr. Avery's guilt. And the footnote for that says Bobby was one of only two witnesses whose testimony the jury requested to review during deliberations. Okay, back to because the state used it to establish that Ms. Halbach never left the Avery property alive. Yet her bones are found, her alleged bones are found at the quarry. Interesting. At trial, Bobby testified that he observed Ms. Halbach's light green or teal colored SUV pull up in his driveway at 2:30 p.m. on October 31, 2005. Bobby then observed Ms. Halbach exit her vehicle and start taking pictures of his mom's maroon van right in front of his trailer. Bobby testified that he then observed Ms. Halbach walking towards the door of Mr. Avery's trailer. If you go into our Facebook group, the MAM Gossip group, and you go into the pictures there, and also videos, I have gone to the salvage yard several times. And so I took pictures from where the van had been parked. The caravan was parked. And so towards what was Barb's trailer at the time and where Steven had lived. So you can see how far away those things are. Plus I have video where I stood where the van was and my husband was down at the mailboxes, which was the bus stop, where this is something bus driver Lisa something. I think her name was Lisa something. So Lisa something, if you're watching this, or somebody who knows Lisa, the bus driver, I would love to talk to you. It's been one of my biggest things that has always stuck with me. And so the first time I had gone to the salvage yard was something that I really wanted to do, because how did this bus driver see Teresa Halbach taking pictures? And so I'm wearing an orange shirt and I'm holding a camera. I brought a real camera with me. And my husband was down at the mailboxes where the Dassey boys was dropped off. And then he has it zoomed in so you see me from where he was. And then he zooms out to now what the eye sees. You can't tell what color shirt I have. I'm male or female. I mean, people could say they don't know that regardless. But there is no possible way that bus driver could have seen Teresa Halbach taking pictures of that red van where it was parked in front of what was Barb's trailer at the time. Just like I have a video. I think it's also on this page, on the YouTube. I think it's like on, because it's actually posted on my husband's YouTube page. But I think it's on here as like a favorite video or something that you can find. And I know it's been posted in MAM Gossip too, where my husband and I walked the Pam Sturm of God path, Pam of God. And we timed it. And I know there's no possible way Pam Sturm could have found the RAV4 in the period of time that she did without being told where to go. So those are just some of the other things you can find. Okay. The following exchange occurred between Prosecutor Sweaty Sweat Sweat. I'm adding the Sweaty Sweat Sweat. Kratz and Bobby. Question. After seeing this woman walking toward your Uncle Steven's, did you ever see this woman again? Answer. No. Next section. Applicable law regarding Denny. When a defendant seeks to present evidence that a third party committed the crime for which the defendant is being tried, the defendant must show a legitimate tendency that the third party committed the crime. In other words, that the third party had motive, opportunity, and a direct connection to the crime. To support the introduction of third party perpetrator evidence, there must be a legitimate tendency that the third person could have committed the crime. The defendant need not establish the guilt of the third party to the level that would be necessary to sustain a conviction. However, evidence that simply affords a possible ground of suspicion against another person should not be admissible. The legitimate tendency, when I'm doing this, is because it's in quotes here, and sometimes it's just easier for me to do this than to go quote unquote. So that's what's in quotes. The legitimate tendency test asks whether the proffered, is that how you say that? Evidence is so remote in time, place, or circumstances that a direct connection cannot be made between a third person and the crime, unquote. Next section is titled, The Denny Requirements Are Now Satisfied. A. Bobby's motive to commit the murder of Teresa Halbach. Under the motive prong, the court must question whether, quote, the alleged third-party perpetrator had a plausible reason to commit the crime, unquote. Citing other cases. Defendant's motive to commit a homicide is widely considered to be relevant. The admissibility of evidence of a third party's motion to commit the crime charged against the defendant is similar to what it would be if that third party were on trial himself. Other acts evidence, that's what it says, may be admitted when offered for other purposes, such as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. Law enforcement considered pornography as evidence of motive in Ms. Halbach's murder. The clear working theory of the investigators was that the murder of Ms. Halbach was motivated by sexual assault. Pursuant to that theory, the Dassey computer was seized by law enforcement on April 21, 2006. Something to note there. Steven kept telling his attorneys to get that computer. And after he was talking to them, telling them to get that computer, then the state gets it. State's not supposed to be listening to his legal stuff. But we know now that, because Kratz has talked about it, that they were spying on Buting and such when they were in with Steven. Evidence of Bobby's motive to commit Ms. Halbach's murder is contained on the hard drive of the Dassey computer, namely the material contained on the Veli CD. The appellate court acknowledged this evidence could be relevant for establishing the motive element of the Denny test if the new evidence directly connecting Bobby was raised. Specifically, the appellate court stated, quote, the evidence, Sowinski's evidence, presented might supply the missing direct connection. In that event, the Veli CD might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect, unquote. Detective Veli's forensic examination of the Dassey computer searched for specific words the user had used or had searched. Detective Veli selected the specific words, and conducted a search for those words. There were 2,632 search results for the following words: blood, 1; body, 2,083; bondage, 3; bullet, 10; cement, 23; DNA, 3; fire, 51; gas, 50; gun, 75; handcuff, 2; journal, 106; MySpace, 61; news, 54; RAV, 74; stab, 32; throat, 2; and tires, 2. These selected words establish a direct link between the specific evidentiary items related to the Halbach murder and the searches performed on the Dassey computer. The Valley CD contains the state's recovered pornography images relevant and material to the Halbach murder. The Valley CD refined the 14,099 images on the 7 DVDs that trial defense counsel received in discovery and recovered 1,625 violent pornographic images. And now this section is in italics, which had been deleted. The recovered porn depicted violent images of the torture and mutilation of young females. Brad Dassey, Barb's stepson and the half-brother of Brian, Bobby, Blaine, and Brendan, avers that he had a conversation with Barb in which she indicated that she had hired someone to remove evidence from the Dassey computer. The authorities interviewed Brad after he reported this information, but he was not called as a witness by either side to testify at Mr. Avery's or Brendan's trials. Affidavit of Brad Dassey. Oh, just saying that's evidence. This is corroborated by the law enforcement report, which states that on June 6, 2006, Special Agent Fassbender and Investigator Wiegert interviewed Brad, who provided this information about the Dassey computer deletions. We are on page 20 of 149. The new forensic examination of the Dassey computer corroborates the affidavit of Brad. Mr. Hunt, in his computer examination, detected 8 periods in 2005, close to the date of the murder, for which files are missing and, quote, presumably deleted from the Dassey computer, unquote. August 23 to 26, August 28 to September 11, September 14 to 15, September 24 to October 22, October 23 to 24, October 26 to November 2, November 4 to 13, and November 15 to December 3. In reviewing images contained on the Veli disc, Special Agent Thomas Fassbender made the following observations. 1. Photographs of both Teresa Halbach and Steven Avery with an apparent date of April 18, 2006. 2. There were numerous images of nudity, both male and female, to include pornography. The pornography included both heterosexual, homosexual, and bestiality. There were images depicting bondage, as well as possible torture and pain. There were also text images with the name Emily. There were images depicting potential young females, to include an infant defecating. There were images of injuries to humans, to include a decapitated head, a badly injured and bloodied body, a bloody head injury, and a mutilated body. And 3, The disc received from Detective Veely, as well as the hard copy pages of instant message conversations, were maintained in Special Agent Fossbender's possession. Unquote. There is sufficient evidence that it was only Bobby who had access to the Dassey computer during the day on weekdays between approximately 7 a.m. to 3:30 p.m. Barb's work schedule was from 6 a.m. to 4:30 p.m. every day, Monday through Thursday of every week. And Barb works. She is gone. That is, yes. Brendan and Blaine would get picked up by the school bus at Avery Road between 7:08 and 7:13 a.m. and dropped off at the same place between 3:30 p.m. and 4 p.m. Therefore, Barb, Blaine, and Brendan, the three other individuals living at the Dassey residence, are excluded from even having access to the Dassey computer at the times most of the violent searches occurred. I don't know if the next section talks about this, but Barb's husband at the time, Tom Yanda, didn't live there. I know that's something that Carla likes to throw out there. Oh, Tom Yanda could have been looking up on the computer. He didn't live there anymore. Barb's, Barb and him were done, and she had been having this affair with Tom Yanda's cousin, Scott Taddock. Tom Yanda was not there. And then Carla also likes to say, well, Steven could have done it. Steven had his own computer. If you're going to look up porn, you're not going to go, I'm going to go to my sister's house and go look up on her computer, because Jody, the drunk, was in custody. So it's not like he'd be trying to then needing to sneak around so his girlfriend didn't catch him looking up porn. Girlfriend got caught for being drunk again. So she's not even there. And Steven didn't have access to Barb's trailer. Not going into her place. So he's the only one home. Bobby is the only one there. And her other son, Brian, wasn't even staying there anymore. He was living with a girlfriend, and he would show up sometimes and, get some of his stuff because, it wasn't a permanent move out. I did that. I moved out of my parents' house when I was 17 and in with my boyfriend at the time, but I didn't take everything out of my parents' house. I would go back and get some stuff from, it was like a slow move over. So that's what Brian Dassey was doing. And so Brian Dassey wasn't living there and he worked. So Bobby is the only possible one that would be home to look up these things. And so if you're going to convict Steven saying that this is sexual deviancy and you have zero evidence, my freaking tag in my shirt is itching the crap out of my neck. But you're trying to say there's some sexual deviancy of Steven where there's no evidence of it whatsoever. And this is on Bobby Dassey's computer. It was in Bobby Dassey's room, but done at times only Bobby Dassey is there. And it's like, let's not look at this. If you're truly a law enforcement official or a lawyer or whatever of any kind, you should be wanting to find who actually did something and not trying to cover up, going, even if you find out years later or whatever. It's, oops, nope, let's bury this because we have to make sure the guy we put in there stays in there. There's no justice in that. And you're leaving somebody out on the streets who could be doing this to who knows how many other people. Okay. Moreover, 128 searches of the most violent porn images primarily occurred on weekdays when only Bobby was in the Dassey residence. It is undisputed that Mr. Avery never accessed the Dassey computer. He did not have the password for the Dassey computer, nor did he possess a key to the Dassey residence, which was locked when no one was home. The only time Mr. Avery ever entered the Dassey residence was when one of the Dassey family members was home. Mr. Avery worked at the Avery salvage yard during the weekdays from 8 to 5. Steven works. And the only time then he's not working from 8 to 5 is he would have lunch with his mom. So he would take his lunch. Steven enjoys working on cars. So he's working. He's not lazy like his brother Earl. So from 9 to 5, Steven is, ripping apart cars and doing whatever. He's not looking up porn. Moreover, Mr. Avery would be eliminated from all but 15 of the 128, which would be 11.7%, searches for the most violent porn images at issue simply by having been arrested on November 9, 2005. So you've already taken him into custody, yet Bobby's looking up the stuff. Brendan would be eliminated from all but 26 of the 128, which is 20.3%, searches for the most violent porn images at issue simply by having been arrested on March 1, 2006. Bobby testified that on October 31, 2005, he was the only person home between 6:30 a.m. when he claims he left to go hunting at 2:45 p.m. Therefore, it is undisputed that Bobby was the only person home on October 31 when searches were made on the Dassey computer at 7 a.m., 9:33 a.m., 10:09 a.m., 1:08 p.m., and 1:51 p.m. prior to Ms. Halbach's arrival at the Avery salvage yard. The timing of these internet searches on October 31 directly contradicts Bobby's trial testimony that on that day he was asleep from 6:30 a.m. to 2:30 p.m. On November 17, 2017, in an interview of Bobby by state investigators, Bobby claimed that the Dassey computer was located, quote, on a desk in the living room at the time, unquote. When Bobby was asked if the computer was ever located in his bedroom, he stated, quote, it was not, unquote. Bobby's statement is directly contradicted by the crime scene footage taken by Sergeant Tyson on November 12, 2005, which shows the Dassey computer was located in Bobby's bedroom. Bobby's statements are further contradicted by his brother Blaine, who stated in his affidavit to current post-conviction counsel on June 25, 2018, that the Dassey computer was located in Bobby's room and Bobby was the primary user of it. Wisconsin statute blah blah provides that, quote, evidence of other crimes and or wrongs and or acts ... When I say ... that's because there are 3 dots here, and what that means is there's other text, but it's been edited out because it's just making this more succinct, more, the stuff, the part it's leaving out doesn't have any relevance. So, but I like to include it so you know. So acts ... when offered ... as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident, unquote, is admissible. The depicted acts in the violent pornography Bobby was viewing are sufficiently similar to the violent murder of Ms. Halbach, which, again, I mean, I get the case that Kathleen is making, but I'm still like, I don't know what happened to Teresa. The evidence, other than Bob, if something bad happened to her, Bobby is where the evidence points. The evidence of Bobby's, did I read that? No. Okay. The evidence of Bobby's searches for violent pornographic images is not so remote in time as to be inadmissible, but rather so close in time to Ms. Halbach's murder that the searches are direct evidence of Bobby's motive to kill Ms. Halbach. I don't know if it's in here, Um, but Steven told me, okay, once upon a time, I used to visit with Steven, and Steven used to call me. So let me go through again my pictures of me with Steven. This was my first time that I visited Steven. Um, this is another picture of the first time I visited Steven. And then there's that time I visited Steven. And then this is a picture Steven had sent me. He mailed me that he wanted me to post on Steven Avery Project, where he wrote "Love my supporters" on it. So one of the things Steven has told me is that Bobby always noticed when Teresa Hallbach was there, because then he would always comment to Steven and um tease him about Teresa Hallbach coming that day. Um so why is 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 Bobby so concerned and keeping track of when Teresa Hallbach was going to be at the salvage yard? Pretty interesting. Because she was there, what, 4 times previously, I think it was, which is not odd. Okay. Steven likes working on cars. It's a freaking junkyard. And so, of course, Steven's going to try and fix up some of these junk cars and try to sell them. Why wouldn't you? Right. So, you're going to list it in Auto Trader. And I'm old, I'm 51. Back when I was in high school, we regularly grabbed the Auto Trader magazine for looking for what cars we were going to buy, or just to look at them. Auto Trader was a big thing then. We didn't, uh, uh, um, internet wasn't, the internet was there, but not a big deal. You were still looking at paper copies of stuff. And so Auto Trader is a big deal. So yeah, you would try and sell things through Auto Trader. Just like it's then not a big deal that Steven would say when calling Auto Trader, send that girl that's been here before. That's not premeditation. Um, that's I've worked with this girl before. I know what she does, just send that same girl out. If Steven is planning to do something to Teresa Hallbach, he had her cell phone number. Because when Teresa would be sent out to take a picture for Auto Trader, she would make $10 for the picture. But if it was what was called a hustle shot, meaning she convinced somebody to sell their vehicle through Auto Trader and takes the picture of it, she would get $20. So, hell yeah, absolutely. She would give her number to Steven. And it's like, so when you want something sold, call this number, not Auto Trader. So if Steven's like, oh, I'm obsessed with this girl and I'm going to kill her, why would you call Auto Trader and make there be a record for where she's going to be and kill her? That makes zero sense. Steven is not the smartest person in the world. I'm not the smartest person in the world, but Steven's smarter than that. And there was no, oh, he said be Yonda when telling the person. It's because Auto Trader would bring and hand you a bill of sale thing that you could fill out when people then bought your car. And so the car belonged to B Yonda. So that's the name he gave. But it wasn't him trying to hide where he was, because Teresa had talked to the chick, April from Auto Trader, and said she's going to the Avery brothers. There was no secret that she was going there. And don't give me the shit too that, oh, she was scared because of the one time she showed up there and he was in a towel, so they say, when Steven's got a freaking pool in the backyard and he's got a towel on. There doesn't mean anything if Steven has a towel wrapped around him. And she didn't have to go. It's not a job where you have to go. You would say, if she was so worried about going there, she'd say, no, I'm not comfortable going there. I'm not going there. She laughed about it on the phone to April about the towel incidents. There was no, I'm afraid, and I felt he was being pervy. I just laughed, this guy. So none of that. So he would have called her directly. He had her direct number, but he called Auto Trader because this was for Barb and he was keeping everything, official, that it was going to be sold and Barb would have to sign the title, all that kind of crap. So be Yonda. No secret the Averys all live in that compound. No. So there's just nothing there. The 1,625 previously deleted but recovered images of violent pornography could have established motive for trial defense counsel's Denny motion. The court in blah, 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 some other case, talking about some other case, don't care, still talking about other case. Okay. Ms. Halbach was killed in a violent manner. Again, I differ here. I say we don't know what happened to her. Maintaining the violent porn images is probative. I don't know. To establish that Bobby had an obsession with violence and therefore was more likely to commit murder. The violent porn images are relevant to Bobby's motive and would have resulted in trial defense counsel being able to establish his motive for Ms. Halbach's murder to meet the Denny standard. As Mr. Avery's sexual homicide expert, Ann Burgess, PhD, opines in her affidavit submitted previously to this court, there is a well-established causal connection between pornography consumption and violent behaviors. In Mr. Avery's motion to consider this court's prior decision, former FBI agent and police procedure expert Greg McCrary submitted an affidavit wherein he described his opinion that the searches for violent, underage, and child pornography, combined with the images of and searches for dead bodies, quotes, reflects a comorbidity of sexual paraphilias, unquote. It is the opinion of Mr. McCrary that, quote, Bobby Dassey was becoming obsessively deviant in his viewing of violent pornography, unquote, in the weeks before Ms. Halbach's murder. This section is titled Bobby's Opportunity to Commit the Murder of Teresa Halbach. The second prong of the Denny test, the opportunity prong, asks, quote, could the alleged third-party perpetrator have committed the crime directly or indirectly? In other words, does the evidence create a practical possibility that the third party committed the crime? Unquote. As a legal concept, opportunity appears in the Wisconsin statutes in the context of other acts evidence. And then blah, 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 their case stuff on that. More case law. Okay. According to the trial court, Mr. Avery's trial defense counsel has already established that Bobby had the opportunity to commit the murder of Ms. Halbach. The Sawinski evidence greatly strengthens the opportunity argument because Bobby is in possession of Ms. Halbach's vehicle where her murder likely occurred. Next section is titled Bobby's Access to Items of Evidence to Frame Mr. Avery. Now my throat's starting to hurt from talking so much. Additionally, the defense theory that Mr. Avery was framed by evidence being planted in Ms. Halbach's car and Mr. Avery's trailer and burn barrel. The Sawinski evidence that Bobby was in possession of Ms. Halbach's vehicle provides the opportunity access to the items that were used in the frame up. The specific items that were planted and used in the frame up of Mr. Avery were Mr. Avery's blood in Ms. Halbach's vehicle, Ms. Halbach's RAV4 key in Mr. Avery's bedroom, and Ms. Halbach's electronic devices in Mr. Avery's burn barrel. Next section is Bobby had access to Mr. Avery's blood. Mr. Avery told law enforcement in a recorded interview that his finger, which had been cut open prior to October 31, 2005, re-bled on November 3, 2005, and dripped blood in his bathroom sink and on the bathroom floor. In Mr. Avery's trial, Raleigh Johnson, the owner of Mr. Avery's trailer, testified that he observed that the cut on Mr. Avery's finger was present prior to October 31, 2005. Mr. Avery consistently expressed his belief to his attorneys and the media that his blood found in Ms. Halbach's vehicle was planted and that it came from his bathroom sink. And Steven stated that from the get-go. Mr. Avery's claim that he bled into his bathroom sink and on the floor was corroborated by the fact that law enforcement found some of his blood around his bathroom sink and on his bathroom floor. In the early evening of November 3, 2005, Sergeant Andrew Colburn, Mr. Netflix sewer, came to the Avery salvage yard and spoke to Mr. Avery. After meeting with Sergeant Colburn, Mr. Avery went to his vehicle and drove to the Dassey residence. Barb, Blaine, and Bobby were home at the time. Mr. Avery provided an affidavit on June 29, 2018. He stated the following in his affidavit regarding the events of the evening of November 3, 2005. Quote, I stopped at my sister, Barb Dassey Yanda's property and broke open a cut on the outside of the middle finger of my right hand as I was attempting to unhitch her trailer for her. ... I went to Barb's door to see if any of her sons wanted to go with me to Menards. Bobby and Blaine were home. I asked Bobby and Blaine if they wanted to go with me and my brother Chuck to Menards. I told both of them that a law enforcement officer had just left the property asking me questions about Ms. Halbach's visit to photograph Barb's van on October 31, 2005. I noticed that Bobby was immediately nervous after I mentioned the visit by the officer. He said that he could not go with me to Menards and that he had things to do. There's no doubt in my mind that Bobby saw that my finger was bleeding. My memory is that Blaine said he wanted to go to Menards and he went with Chuck and me. Prior to leaving for Menards, I returned to my trailer to put tape on my bleeding finger. A large amount of my blood dripped into the rim and sink and the floor of the bathroom. I did not wash away or wipe up because Chuck was waiting for me to go to Menards and Manitowoc with him. While we were leaving Avery property, driving a flatbread to Menards and Manitowoc, I saw taillights in front of my trailer. Taillights were further apart and higher off the ground than sedan taillights. I told my brother, who was driving, about the taillights. We turned around and drove to my trailer, but the vehicle was gone. On November 4, I woke up at 6 a.m. and went into the bathroom to take a shower. I saw that most of the blood on my sink, which I had not cleaned up the previous night, was gone. It seemed to me that the blood had been cleaned up. After reviewing more case documents and thinking about what happened on November 3, 2005, I do not believe that law enforcement broke into my trailer and took blood from my sink and planted it in Ms. Halbach's vehicle. Unquote. According to Mr. Avery, he left his door unlocked when he went to Menards. However, the Dasseys also had a key to his residence. Mr. Avery told law enforcement and trial defense counsel that as he was leaving his property around 7 p.m. on November 3, 2005, and exiting onto Highway 147, he observed taillights of a vehicle close to his trailer. Mr. Avery also told trial defense counsel that he noticed that his blood had been removed from his sink when he entered his bathroom early in the morning on November 4, 2005. Next section titled Bobby's Direct Link to the Murder of Ms. Halbach. The third and final prong of the Denny test asks whether there is, quote, evidence that the alleged third party perpetrator actually committed the crime directly. The Slawinski evidence demonstrates that Bobby could have committed the murder because he is in possession of Ms. Halbach's vehicle, where the murder likely occurred, as evidenced by Ms. Halbach's blood in the vehicle. The vehicle is a key piece of evidence in the crime. Another case stuff. The new evidence that Ms. Halbach's vehicle was returned to the Avery salvage yard from a different location is corroborated by the fact that a witness saw a vehicle similar to Halbach's leave the property on October 31. In Mr. Avery's trial, Mr. Lurquin, a propane driver, testified that he saw a green midsize SUV leaving the Avery salvage yard driving towards Highway 147 between 3:30 and 4 on October 31. He informed law enforcement about this when he stopped at a roadblock a few days later and had heard about the news of Ms. Halbach being missing. The color of the RAV. We go over this every time. I am not of the belief that there are two RAVs. The color of her car was called Mystic Teal. It's a car, depending on the sunlight, would look green or blue. So I do not feel that there is a green or a blue. I had a car that was blue, but most people, including Manitowoc, thought it was black. Because when I got busted for, as Earl called it, trespassing, when I was at the quarry, they so what they did is they got into MAM gossip, where I had done a Facebook Live when I was walking at the deer camp. And so when I was walking through the deer camp and doing Facebook Live in MAM gossip, my husband was driving my car alongside me. And so they have a screenshot. Chris, so people are saying no sound. Is everybody having problem hearing me? Is there something going on there? I see Carol saying no sound and somebody saying you are breaking up. Okay, Michael says he hears me, so I'm going to keep going. So sometimes it's not me and it's you or whatever. Sometimes people got to go out and come back in. Okay. So they the cops took a screenshot where you could see my reflection in my car. Thank you, everybody, telling me that you can hear me now. And so when I received the ticket in the mail, and then also I had to go to court. Thank you, Christopher. When I had to go to court, they said my car was black, and my car is not. My car is blue. So, and I don't even have that car now. But, yeah. Okay, okay. The new evidence that Ms. Halbach's vehicle, I already read that part. Okay, I read that part. All right, here I am now. Further, it is corroborated by Bobby's brother Blaine's account On June 25, 2018, Bobby's brother, Blaine, provided Mr. Avery's current post conviction counsel with an affidavit attesting, quote, on October 31, 2005, when the school bus driver brought Brendan and me home as we traveled west on um what is that, state highway, is that what STH is, state highway 147, I saw Bobby on 147 in a bluish or greenish vehicle heading towards Mishicot. Bobby was not driving his black blazer. Bobby was not home the rest of the evening while I was home, unquote. Bobby's trial testimony contradicts Blaine's affidavit because Bobby testified that he was home at 5 p.m. Bobby's own freaking brother saw Bobby driving Teresa's car. And law enforcement in the court doesn't think that's suspect. Bobby was with Michael Osmondson when Ms. Halbach's vehicle was discovered on November 5, 2005. Osmondson's the one that had claimed he was with Steven when Steven said something about hiding a body. Current post-conviction counsel's investigator met with and interviewed Osmondson about whether he was the individual with Bobby pushing the RAV4 onto the Avery salvage yard. The interview was conducted because Osmondson fit the height, weight, and beard description provided by Mr. Sawinski of the individual helping Bobby push the car. When Osmondson was asked if he was the individual who helped Bobby push the vehicle on the Avery property on November 5, 2005, Osmondson responded that he could not remember if he was that individual. What the actual fuck? That's not how you respond if you're innocent and didn't do anything. Could not remember. You don't say that. You say no. How do you not remember pushing a car somewhere? This was, so Michael Osmondson was Bobby's best friend. And until Bobby left Facebook, when Kathleen first started targeting him, you can probably still look. I don't know if the page is deactivated, but he and Michael Osmondson were still Facebook friends. And did Michael Osmondson date Marie? Michael Ryan, are you still on here? You might remember that. Or Millbilly, you might remember that. Did Osmondson date Marie? Marie was Earl's stepdaughter. But you don't say could not remember when you know. I mean, and you what was the date that I when what the date was that on but he, thank you, Michael. So all about this case when Osmondson's talking to Zellner or Zellner's people. Yeah, word there, Michael. um so you absolutely wouldn't say I can't remember a for that's the vehicle of the girl that everybody is saying murdered. So you would say, no, I've never seen that car. Why you would not say I can't. That's huge. Again, with going suspect, come on. Further evidence of Bobby's dishonesty. Bobby never reported to law enforcement the alleged statement Mr. Avery about whether they wanted to help him get rid of a body, unquote. Combined reports re-interviews of Bobby Dassey. That was a major deal. Trial defense counsel moved for a mistrial, pointing out that they had never been apprised of Bobby's new claim. During Bobby's direct examination, prosecutor Sweat Kratz asked Bobby, quote, "Now, Bobby, on the 3rd of November, on the 3rd of November, should I be doing that in a high pitched voice? That would be a Thursday, I believe. Do you recall having a conversation with your Uncle Stephen regarding a body?" Unquote. And the Dassey boys didn't call him Uncle Stephen. They just called him Stephen. Um, and Bobby responded, quote, "Yes," unquote. On cross examination, Bobby testified that Mr. Avery stated this remark about getting rid of a body in jest on November 3, 2005, when he and Osmondson. However, Osmondson told law enforcement that Mr. Avery made such a statement to them on Thursday, November 10, 2005. The only time Osmondson was at the Dassey residence between October 31 and November 11th, when he and Bobby were inside the Dassey garage and Mr. Avery came over. This is November 9, 2005. So, how is Steven saying this the day after he's arrested? Remarkably, Osmondson stated to law enforcement that he found the missing girl on Tuesday, November 1, 2005, when Ms. Halbach had not yet been reported missing. The record reveals that Osmondson and Bobby were either suspiciously calling each other repeatedly or with each other at relevant times after Ms. Halbach's murder. Phone records reflect that on October 31, 2005, there were 7 phone calls between Bobby and Osmondson, occurring between the following times in the morning and evening: 6:12 a.m., 6:36 a.m., 3:56 p.m., 3:57 p.m., 3 p.m., 5:10 p.m., and 6:01 p.m. Bobby's phone records revealed that Bobby called Osmondson a total of 66 times from October 24, 2005 to November 9, 2005. The Sawinski evidence is newly discovered and directly links Bobby to Ms. Halbach's murder because, as previously stated, Ms. Halbach's RAV4 was a key piece of evidence in her murder. Next section, titled "The Evidence is Not Cumulative." The Sawinski evidence provides, for the first time, the missing direct connection to Bobby as a third-party suspect for Ms. Halbach's murder and is therefore not cumulative. Next section, responsible doubt as to Mr. Avery's guilt. And oh my God, we've been on here almost Billy. I am on page 30 of 149. Stretch. If the defendant satisfies all 4 criteria of newly discovered evidence, the reviewing court whether it is reasonably probable that, had the jury heard the newly discovered evidence, it would have had a reasonable doubt as to the defendant's guilt. Other case. Overwhelming evidence against the defendant may not serve as a basis for excluding evidence of a third party's opportunity or direct connection to the crime. Quote, by evaluating the strength of only one party's evidence, no logical conclusion can be reached regarding the strength of contrary evidence offered by the other side to rebut or cast doubt. Unquote. In this case is completely undermined. The newly discovered evidence that Bobby was in possession of Ms. Halbach's vehicle means that he had opportunity and access to plant evidence in the vehicle and from the vehicle. Bobby has been directly linked to the murder of Ms. Halbach, there's reasonable inference that he planted the bones in Mr. Avery's burn pit. The new evidence creates a reasonable probability that, had the jury heard the new evidence, it would have had a reasonable doubt as to the defendant's guilt. Therefore, Mr. Avery should be granted a new trial. Section 2 is Brady violation regarding the Sawinski. Sawinski evidence is not only newly discovered evidence, but it also meets the criteria for a Brady violation. After Mr. Sawinski contacted post-conviction counsel and provided the newly discovered evidence, Mr. Avery's current post-conviction counsel, through its investigator, submitted public records request pursuant to the Freedom of Information Act for audio recordings of incoming and outgoing phone calls and or radio dispatch in November 3, 2005 and November 9, 2005 that relate to the Halbach case. The FOIA audio recordings did not contain the Sawinski call on November 6 at 10:28 p.m., nor did they contain any dates or times of the calls produced. The plot thickens. In May of 2022, Mr. Avery's current post-conviction counsel received the previously suppressed Sawinski call to the Manitowoc Sheriff's Office, which contained a partial recording of the suppressed call to the Manitowoc Sheriff's Office on November 6, 2005. For the first time, current post-conviction counsel received the incoming calls. Attached and incorporated herein is Exhibit D, timestamp record from the disclosure dated in May of 2022. As part of its further investigation, Mr. Avery's investigator interviewed Mr. Sawinski's ex-girlfriend, whom he was dating at the time of the November 2005 incident. Mr. Sawinski's ex-girlfriend, Devin Novak, corroborated Mr. Sawinski's account of what he had witnessed and what he had relayed to law enforcement. Further, Ms. Novak recognized and identified Mr. Sawinski's voice on the recording played to her by the investigator of a phone call made to the Manitowoc Sheriff's Office on November 6, 2005 at 10:28 p.m. Mr. Avery also interviewed Mr. Sawinski again and played the same audio recording of the phone call that was made to the Manitowoc Sheriff's Office on November 6, at 10:28 p.m. Mr. identified his voice in the audio recording of the phone call from November 6, 2005. The recording of Mr. Sawinski's call, there's a footnote. Let me go to the footnote. After realizing that he did not contact Mr. Avery's trial defense counsel, contacted the Innocence Project in 2016, Mr. Sawinski provided current defense counsel with his new affidavit, which also corrects his prior affidavit, Avery's motion to stay in remand in the appellate court, in which Mr. Sawinski stated that he contacted Mr. Avery's trial defense attorneys. All right, so back up. The recording of Mr. Sawinski's call was never disclosed by the state to Mr. Avery's trial defense counsel prior to or during the trial. Defense counsel made two specific requests pursuant to Wisconsin statute, blah, 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 for all exculpatory evidence and or information, possession, knowledge, or control of the state, which would tend to negate the guilt of the defendant, or which would tend to affect the weight or credibility of the evidence used against the defendant, including any inconsistent statements. A second request was made by trial defense counsel for Brady material for trial on January 8, 2007. Affidavits of Mr. Avery's trial defense counsel, Mr. Dean Strang, and Mr. Exhibit of trial defense counsel's July 24, 2006 letter to prosecutor Kratz requesting all audio tapes. Next section is applicable law regarding Brady. In Brady, the Supreme Court held that the prosecution violates an accused constitutional right to due process of law by failing to disclose evidence favorable to the defense. Maryland versus to establish a Brady violation, a defendant must demonstrate that one, the prosecution suppressed evidence. Check. Two, the evidence was favorable to the defense. Check, check. And three, the evidence was material to an issue at trial. Check, check, check. The state never disclosed the Sawinski evidence or the Sawinski call to Mr. Avery's current or past counsel. The defense never received a law enforcement report of the Sawinski evidence provided by the Sheriff's Office in November of 2005. The Sawinski evidence is corroborated by the partial recording of his attempt to report the evidence to the Manitowoc Sheriff's Office prior to his call being transferred. There is no recording or law enforcement report of the remainder of Mr. Sawinski's call that Mr. Avery's current post-conviction counsel, through reasonable diligence, has been able to locate through its public records requests. So it does. Here's another case, another case, another case. There is no duty for the defense to seek out information that has not been disclosed. However, Mr. Avery's current post-conviction counsel has made diligent efforts to obtain any and all information regarding the Sawinski evidence, including re-requesting all incoming calls to the Manitowoc Sheriff's Office from the relevant time period. The following timeline illustrates the diligence demonstrated by Mr. Avery's current post-conviction counsel in investigating and corroborating the evidence that Mr. Sawinski provided to the Manitowoc Sheriff's Office on November 6, 2005. Let me take another sip for my tea from the State Fair. All right. December 26, 2020 at 10:42 p.m. Mr. Sawinski emailed Steven Avery lawyers at gmail.com a summary of what he had observed on November 5, 2005. The subject line of his email was, quote, "We need to talk," exclamation point, unquote. Investigation of Thomas Sawinski's credibility. Mr. Avery's current post-conviction counsel conducted an investigation of Mr. Sawinski, which included gathering information about the following: his date of birth, relatives, employment history, telephone numbers, email addresses, possible criminal record, possible civil record, and car and home ownership. Mr. Avery's current post-conviction counsel confirmed that Mr. Sawinski had worked for the Manitowoc Herald-Times during the relevant time period. Financial documents dating 2005 to 2006, as well as newspaper articles from 2005 2006, listed Mr. Sawinski as a paper carrier of the Manitowoc Herald-Times. Mr. Avery's current post-conviction counsel contacted Mr. Avery's trial defense counsel, Mr. Buting, who confirmed that Mr. Avery's trial counsel had any email Sawinski. Mr. Avery's current post-conviction counsel all discovery and FOIA requests made by prior current post-conviction to the Manitowoc Sheriff's Office. Any information relating to the Sawinski evidence was encompassed within those requests and should have been produced, but was not. April 7, 2021. Mr. Avery's current post-conviction counsel sent and delivered a letter to Mr. Sawinski through a local investigator in Denver, Colorado, where Mr. Avery's current post-conviction counsel determined that Mr. Sawinski resided. Mr. Avery's current post-conviction counsel's office immediately. Okay, wait. Now it says my connection is unstable. Please wait while we try reconnecting. All right, so somebody tell me Can you hear me now before I keep reading? Somebody give me the thumbs up. Maz, you can hear me? Thank you. Yeah. I mean, and it seems too the longer I'm on, sometimes the crappier things get. So sorry about that. We've been going for 2 hours now. Um Okay, April 8, 2021. Mr. Avery's current post conviction counsel and her clerks had telephone contact with Mr. Sawinski and arranged a time to speak to him further. April 9, 2021. Thank you, everybody, for letting me know. Mr. Avery's current post conviction counsel and clerks conducted a phone interview of Mr. Sawinski. Mr. Avery's current post conviction counsel prepared an affidavit for Mr. Sawinski based on his statements in that interview. Mr. Sawinski indicated that he was going to be visiting family in Manitowoc on April 10, 2021. April 10, 2021. Post conviction counsel's investigators, Stephen Kirby, met Mr. Sawinski in person in Manitowoc for an interview and reviewed his affidavit with him. The affidavit described the evidence Mr. Sawinski reported to the Manitowoc Sheriff's Office about what he observed on the Avery property while delivering newspapers on November 5, 2005, as well as the actions he took afterward. After reviewing his affidavit and making any necessary changes, Mr. Sawinski executed the affidavit before a Wisconsin notary. I'm a notary. April 12, 2021. Mr. Avery's current post conviction counsel filed defendant appellant's motion to stay, appeal, and remand the cause to supplement his post conviction motion with a new witness affidavit establishing a Brady violation and a new third party Denny suspect. I have such a headache right now. And I know it's because of my back. And I haven't had dinner yet. August 28, 2021. Mr. Avery's current post conviction counsel listened to all audio recordings in its possession from discovery as well as its own investigation and determined there was no, it's in bold, no recording matching the description Mr. Sawinski provided to the Manitowoc Sheriff's Office. March 15, 2022. Mr. Avery's current post conviction counsel, through its investigators, submitted the following 3 new public record requests to the Manitowoc County Sheriff's Office. The first sought of any non-911 record in your possession of incoming telephone calls to the Manitowoc Joint Dispatch Center between the dates of November 3, 2005 and 12:01 a.m. through November 9, 2005 at 11:59 a.m. The second request sought copies of incoming and outgoing telephone call logs of the recorded Manitowoc County Sheriff's Joint Dispatch calls between the dates of November 3, 2005, 12:01 a.m. through November 9, 2005, 11:59 p.m. that relate to the Teresa Halbach investigation. Information should include date, time, and telephone numbers involved in the calls. The third request sought copies of audio recordings of incoming and outgoing calls and or radio dispatches between the dates of November 3, 2005, 12:01 p.m. through November 9, 2005, 11:59 p.m. that relate to the Teresa Halbach investigation. May 3, 2022. In response to Mr. Avery's current post-conviction counsel's March 15, 2022 public records request through its investigator for the first time, March 15th, recordings were provided to Mr. Avery's current post-conviction counsel, who thoroughly reviewed and listened to all the audio recordings and located one of interest, what took place on November 6, 2005 at 10:28 p.m. Now this part's underlined. For the first time, the time and date of the calls were revealed on track files. August 6, 2022. Current post conviction counsel's investigator Stephen Kirby met with Mr. Sawinski's former girlfriend, Ms. Novak. Sorry, I was with somebody today who's last. Oh, sorry. Okay, you don't care. On August 22 for her the audio recording from November 6, 2005 at 10:28 p.m. Ms. Novak identified the voice of Mr. Sawinski's. Ms. Novak provided Mr. Avery's current post conviction counsel with an affidavit regarding her voice identification and her recollection of being with Mr. Sawinski when he placed the call on November 6th. When he placed the November 6th call to the Manitowoc Sheriff's Office. August 6, 2022. Current post-conviction counsel's investigator Stephen Kirby met with Mr. Sawinski and played for him the auto recording from November 6, 2005 at 10:28 p.m. Mr. Sawinski identified the voice as the call as his. Mr. Sawinski provided Mr. Avery's current post-conviction counsel with an affidavit regarding his voice identification. As stated above, after a very thorough investigation of Mr. Sawinski individually and of the accuracy of the information he provided as the Sawinski, Mr. Avery's current post-conviction counsel determined that the Sawinski evidence necessitates filing a third blah blah motion. In order for the defendant to prevent the opponent of the Brady analysis, the suppressed evidence must be material. Other cases, blah, 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 blah. Another case. All right. Mr. Avery's conviction for first degree intentional homicide was, in large part, based on trial defense counsel's unsuccessful efforts to name a third party Denny suspect that met all of the Denny requirements. The Sawinski evidence meets the Denny requirements and makes Bobby a third party Denny suspect in the murder of Ms. Halbach. Also, the Sawinski evidence meets the Denny requirements of establishing Bobby as having framed Mr. Avery for the murder, Bobby's possession of Ms. Halbach's vehicle, and to remove evidence from the vehicle and plant it in Mr. Avery's bedroom, and burn barrel, Ms. Halbach's electronic devices. Okay, sorry. I'm saying my connection is unstable again, but I'm gonna. Oh, yeah, okay, it's saying okay. Um. mm, 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 mm. I'm trying to find where I was now. Okay. The disclosure of the audio recording would have led to the identification of Mr. Sawinski as and the evidence he has provided, which directly connects Bobby to the murder and the framing of Mr. Avery. The Sawinski evidence is both material and favorable to Mr. Avery's case. Thank you, Lisa. The Sawinski evidence is material because it makes Bobby a third party Denny suspect in the murder, as well as the source of the planted evidence that was used to convict Mr. Avery. The Sawinski evidence also impeaches Bobby's testimony and refutes the state's theory that Ms. Halbach's RAV4 never left the Avery property and that Mr. Avery was the last person to see Ms. Halbach alive. Further, materially favorable evidence not only includes exculpatory evidence, but also evidence that is impeaching of a prosecution witness. I'm talking about another case. Bobby was the state's primary witness against Mr. Avery at his trial. During his opening statement, Prosecutor Kratz explicitly informed the jury of the significance of Bobby's putative observations on the date of Ms. Halbach's disappearance. You're going to hear that Bobby Dassey was the last person, the last citizen that will have seen Teresa Halbach alive. Bobby testified that he observed Ms. Halbach's vehicle pull up in his driveway at 2:30 p.m. on October 31, 2005. Bobby then observed her vehicle and started taking pictures of his mom's maroon van right in front of his trailer. Bobby testified that he observed Ms. Halbach walking toward his trailer. He testified that he never saw her again after that. He then testified that he took a 3 or 4 minute shower and okay, and then left his trailer to go hunting. Bobby walked to his Chevy Blazer, which was parked between the trailer and garage. He testified that as he walked to his vehicle, he observed Ms. Halbach's vehicle still parked in the driveway. He further testified that he did not see Ms. Halbach or any signs of her. Contrary to Bobby's trial testimony that Ms. Halbach was still on the Avery property when Bobby left to go bow hunting, Brian, Bobby's brother, told law enforcement that Ms. Halbach leave the Avery property on October 31, 2005. On November 6, 2005, special agents with the Wisconsin DOJ Division Investigation interviewed Brian. When the investigators asked Brian about the events of October 31, 2005, he told the investigators that he was not at home during the day other than waking up and going to work. He told the investigators the following, quote, Brian said he heard from his mom and Steven that Halbach was only at their residence about 5 minutes. He heard she just took the photo of the van and left. Brian said the investigators should also talk to his brother Bobby because he saw her leave their property, unquote. The state was in possession of this report at the time of Mr. Avery's trial. Despite knowing this information, the state presented false testimony from Bobby. On October 16, 2017, Brian provided current post-conviction counsel with an affidavit confirming that Bobby told him he saw Ms. Halbach leave the Avery property on October 31, 2005. In his affidavit, Brian stated as follows, quote, on or about November 4, 2005, I returned to my mother's trailer to retrieve some clothes, and I had a conversation with my brother Bobby about Teresa Halbach. I distinctly remember Bobby telling me, quote, Steven could not have killed her because I saw her leave the property on October 31, 2005, unquote. Brian provided Mr. Avery's current post-conviction counsel with this affidavit after Mr. Avery's second post-conviction motion was filed and the circuit court ruled on it. Let me just say about Brian, I've met him in person. I had gone to Barb and Scott's home where we did a Facebook Live in Barb's group. I was a moderator of Barb's group at that time. And so I was doing a Facebook Live where I interviewed Barb, Scott, and Pete Dassey, Bobby's father, Brendan's father. And when it was all done, at some point, Brian Dassey showed up there with his kid. And so I spoke to him for a little bit. Really nice. He told me he had considered legally changing his last name. Didn't want to be associated with anything, and he really didn't following his kids around. And he just wants to do with any of this. But he's the only Dassey boy that I've actually met. The appellate court highlighted the importance of the Sawinski evidence when it stated the following in its July 28, 2021 opinion, quote, to admit evidence at trial that Dassey could have killed Halbach, Avery would have had to provide some evidence at the pretrial Denny hearing directly connecting Dassey to the crime. See state, blah, 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 other case, blah, blah, blah. That Dassey possibly possessed violent pornographic images might have inconceivable conceivably satisfied a separate requirement, motive, but is insufficient in and of itself to allow admission of third party liability evidence. Avery failed to meet the quote direct connection unquote requirement in his original Denny motion and has not presented additional point in motion number 4 unquote. While the appellate court determined that Mr. Avery did not have I'm going to yawn to do it did not have sufficient evidence to meet the Denny requirements to admit evidence at trial that Bobby could have killed Ms. Halbach. It also advised Lewinsky evidence could be that missing direct connection. Because the Sawinski evidence was suppressed, trial defense counsel was not able to establish Bobby as a third party Denny suspect or impeach Bobby's trial testimony as the state's primary witness. As a result, Mr. Avery received a fair trial. Duh. Mr. Avery had a constitutionally guaranteed right to present a complete defense to the charges against him. Cases. Prior to the discovery of the Sawinski evidence, the appellate court stated that impeaching Bobby would not have undermined the cumulative effect of the quote significant forensic and other evidence implicating Avery in a crime committed on his property unquote. However, the discovery of the Sawinski evidence transforms this evidence from implicating Mr. Avery to implicating Bobby in the murder and planting evidence to frame Mr. Avery. Even if this court determines that the evidence implicating Mr. Avery remains significant, it is unconstitutional to refuse to allow a defendant to present a defense simply because the evidence against him is overwhelming. Because of the existence of the new Sawinski evidence, Mr. Avery must be allowed to present a defense based upon it. A reasonable probability of a different result exists if the suppressed information undermines confidence in the verdict. The suppressed Sawinski call undermines confidence in Mr. Avery's verdict. Its disclosure would have led to the discovery of the Sawinski evidence, which establishes Brady as a third party Denny suspect in both the murder and planting of evidence to frame Mr. Avery. It also impeaches Bobby's trial testimony, which he fabricated in order to exculpate himself and frame Mr. Avery for the murder of Ms. Halbach. Let me say here, all right, so for this case, I have an email account, so see behind me, justicewithjax@gmail.com. If you want trials and you would talk to the stuff that comes out, and even if you want to be off the record, I just would love to talk to you. Same thing goes for the bus driver and the coroner that was not allowed on the scene. I would love. So you can email justicewithjax@gmail.com or official Steven Avery project at gmail. We can talk on the phone. We can email, or if you're in Wisconsin, I'll drive to you. Whatever you want to do that makes you most comfortable. And I can keep you completely off the record. If you are somebody who has evidence, I mean, obviously I care about the case and I want to know things, but you go to Kathleen Zellner. You go to KathleenTZellner.com. She has a phone number that is specifically for the Steven Avery case, and there's an email specifically for this case. Please reach out to Kathleen Zellner if you are a witness, you know something, and don't assume she knows it. So please reach out to her. All right, back into this. If I can find where I was. A reasonable probability of a different result exists if the suppressed information undermines confidence in the verdict. The suppressed Sawinski call undermines, yeah, okay, undermines confidence in its disclosure of Denny suspect in both the murder and planting of evidence to frame Mr. Avery. Teaches Bobby's trial testimony, which he fabricated in order to exculpate himself and frame Mr. Avery for the murder of Ms. Halbach. Next section titled Mr. Avery is not procedurally barred from raising his Brady claim. A motion for relief under blah blah quote is original criminal action and may be made at any time unquote. Wisconsin statute, blah, blah. However, a defendant must meet certain requirements. All grounds for relief available to a person under this section must be raised by his or her original, supplemental, or amended motion. Any ground finally adjudicated or not so raised or knowingly, voluntarily, or intelligently waived in the proceeding that resulted in the conviction or sentence or in any other proceeding the person has taken to secure relief may not be the basis of a subsequent motion unless the court finds a ground for relief asserted which, and now this section's underlined, for sufficient reason was not asserted or was inadequately raised in the original, supplemental, or amended motion. Now stating other cases. On April 12, 2021, Mr. Avery filed the Sawinski motion to stay his appeal and remand for evaluation of a new claim. The appellate court determined that, quote, the circuit court should resolve on a standalone basis, unquote. The Sawinski motion through, quote, through a new Wisconsin statute, blah, blah motion, unquote. The appellate court also stated that, quote, pursuant to Excalana Naranjo, Avery will need to demonstrate why he could not have previously raised this claim, including in his June 2017 motion, before the merits can be reached, unquote. Oh my God, I am so tired of talking. Are you tired of listening to me? All right. Current post-conviction counsel could Sawinski motion filed with the appellate court prior to April 12, 2021, and the current motion prior to May of 2022. Therefore, the motion filed in any prior proceeding, including it's sad that she's got to point this crap out and that they can still go, nope, denied. Okay. Therefore, the motions could not have been filed in any prior proceeding, including the filing of the June by Mr. Sawinski to the Manitowoc Sheriff's Office was never provided to Mr. Avery's prior counsel by the state. The state probably didn't even know. The Sawinski evidence was only discovered by Mr. Avery's current post-conviction counsel after being alerted to its existence by Mr. Sawinski in December of 2020 after he watched Making a Murderer. Current post-conviction counsel had to then thoroughly corroborate Mr. Sawinski and the Sawinski evidence. As paragraph 83 above illustrates, and we're on paragraph 112 now, Mr. Avery's current post-conviction counsel was diligent in investigating and corroborating Mr. Sawinski and the Sawinski evidence. The Sawinski evidence provided to the Manitowoc Sheriff's Office on November 6, 2005, was unknown to Mr. Avery and undiscoverable at the time of Mr. Avery's 2017 motion, 2013 post-conviction motion, direct appeal, and 2007 trial. It could not have been known or discovered by Mr. Avery until April of 2021. And the state had suppressed the audio recording of his November 6, 2005 phone call to the Manitowoc Sheriff's Office reporting his observations on November 5, 2005. Our system sucks. Our system sucks. And until we can start holding these people accountable for when they do this crap, because Kratz should be in jail. Colborn, jail. Lenk, jail. All of them. Um, 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 Fassbender, Wiegert, Sherry Colhane, Wendy Baldwin. Prison, 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 prison. All these people should be in prison. Therefore, did I read that part? It is, oh my God, what is this word? Axiomatic. It is axiomatic that the discovery of a Brady violation subsequent, that's in italics, subsequent to filing a motion pursuant to blah, 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 constitutes a sufficient reason for failing to raise the issue in a prior motion. Talking about another case, another case. Even if the court determines the violation, the Sawinski evidence qualifies as newly discovered evidence as described above. Mr. Avery has a sufficient reason brought forth the newly discovered evidence because Mr. Avery did not know and could not have known about the Sawinski evidence until Mr. Sawinski came forward in December of 2020 after Mr. Avery's appeal was pending. Therefore, this court should find that Mr. Avery is not procedurally barred by his newly discovered evidence claim or his new Brady claim regarding the Sawinski evidence. Section 3, titled A Violation Regarding Hallbox RAV4. Kevin Romlow came forth to Mr. Avery's current post-conviction counsel with new information in July of 2017. Mr. Romlow provided an affidavit and supplemental affidavit to current post-conviction counsel. Because Mr. Avery's second post-conviction motion was filed in June of 2017, these affidavits were filed in Mr. Avery's motion to reconsider the circuit court's October 2017 ruling denying his second post-conviction motion. In Mr. Romlow's affidavits, Mr. Romlow described observing Ms. Hallbach's RAV4 parked at the turnaround at 147 at the East Twin River Bridge on November 3 and 4, 2005. Mr. Romlow describes in his affidavit reporting his observation to a Manitowoc sheriff's deputy. There's a fucking bug flying around here. He encountered on November 4, 2005 at the Senex station on 147 in Mishicot. No law enforcement report was ever generated by this Manitowoc sheriff's deputy memorializing the conversation between Mr. Romlow and this deputy. So another thing you can see in our closed Facebook group called MAM is I have taken you guys on field trips several times to Manitowoc, where I drove to all these places, and then we also timed them. So you can watch my past videos that they're just Facebook Lives. I don't know how long it takes to go from the salvage yard to this turnaround 7. And that, because I hit record on my phone and it's just going the entire time. So you see the drive from the salvage yard to the turnaround where the bridge is to the Senex station. I have driven and we have timed it of Teresa Hallbach's possible route for the day, where I go to all the stops that she went to. We starting at Teresa's house. We have gone to the cemetery where Teresa Hallbach is buried, or whatever is buried, whatever is going on there. So you can check those out. To see just how close all these, and Cuts Road, all that, to see how close all this stuff is. All right. Mr. Romlow's observation of Ms. Hallbach's RAV4 on November 3 and 4, 2004 is material to trial defense counsel's theory that evidence was planted. See, when I get tired, I like scratch my head a lot. Um, and since I've shaved my head, it's still this weird getting used to feeling my shaved head. Um, sorry, squirrel. If the RAV4 was spotted at the turnaround on Highway 147 on November 3 and 4, 2005, then it must have been moved and planted on the Avery property before it was discovered on November 5, 2005. Clearly, this information supports trial defense counsel's theory that the RAV4 was planted on the Avery salvage yard before it was discovered there on November 5, 2005. Mr. Romlow's observations on November 3 and 4, 2000, the Hallbach vehicle at the turnabout off of 147 is corroborative of Mr. Sawinski's observation of the RAV4 on Avery Road, which directly intersects 147 in the early morning hours of November 5, 2005. Both witnesses support trial defense counsel's theory that the RAV4 was planted. Prosecutor Kratz admitted in his closing that the RAV4, quote, and onto that property unless somebody knew that property, unquote. Total lie. The only other evidence state that the RAV4 never left the Avery property after October 31, 2005 was Bobby's testimony that the RAV4 was still present when he left the Avery property at 2:45 p.m. So even when I've gone there and I also then drove through the quarry behind it, um you would still be able to there's been a berm that's been built up and everything. You could still to this day finagle through the quarry to get onto the Avery salvage yard. And me that she used to, when she was young, growing up there, at park as the pit, they would the kids would have parties down there. And so they would have people sneak in by driving through the back way. It's no secret. Um okay. Trial argued in the closing that there were, quote, lots of ways to get in and for someone to plant the vehicle, unquote. Next section titled Mr. Avery is not procedurally barred from raising his Brady claim. In the appellate court's July 2021 opinion, the appellate court noted that in Mr. Avery's motion for reconsideration, he raised the issue that, quote, the state withheld evidence that Hallbach's vehicle was seen on the street days after her disappearance, unquote. The appellate court declined ruling on the issue, but advised the following, quote, neither we nor the circuit court have squarely considered whether these claims are procedurally barred under Escalano Naranjo or whether Avery pled sufficient material facts entitling him to a hearing, although our analysis overlaps with the former inquiry. Such consideration would have to come on a separately filed Wisconsin statute blah blah motion, and we express no opinion as to whether such claims would be barred in the event such a motion is filed, unquote. And we are on page 46 of 149. I'm hoping, like usual, like a whole lot of pages at the end or something that we don't even have to cover. Clearly, current post-conviction counsel could not have included Mr. Romlow's affidavits in its June 7, 2017 filing on behalf of Mr. Avery, since Mr. Romlow had not yet come forward with evidence that establishes a Brady violation. There is no way that Mr. Romlow could have been discovered by prior defense counsel or current post-conviction counsel because no law, nor did he appear in any other law enforcement reports in the Hallbach murder investigation. He had never been a customer at the Avery salvage yard, and he had no connection to the family besides being acquainted with Mr. Taddock's brother. Avery was unable to discover the Brady violation with reasonable diligence prior to the filing of his second post conviction motion in June of 2017. Romlow did not come forward to Mr. Avery's counsel until after June of 2017. He came forward in July. It would be impossible for Mr. Avery to have raised his Brady claim without Mr. Romlow first coming forward to current post conviction counsel. Therefore, Mr. Avery has a sufficient reason for not raising this issue previously, pursuant to Escalano Naranjo. Next section. In the alternative, Mr. Avery is entitled to a new trial in the interest of justice. Remember that word, justice? Justice, pursuant to Wisconsin statute, blah, blah. Alternatively, Mr. Avery is entitled to a new trial in the interest of justice. If this court were to conclude that this new evidence warrants a new trial in the interest of justice, this court need not resolve whether the new evidence satisfies the test for granting a new trial. Discovered evidence. Wisconsin statute, blah, blah, establishes that the standard for granting a new trial under circumstances such as these, this new trial would advance the interest of justice, quote, a party may move to set aside a verdict and for a new trial because of errors in the trial, or because the verdict is contrary to law of the weight of evidence, or because of excessive or inadequate damages, or because of newly discovered, or in the interest of justice, unquote. Courts may grant a new trial in the interest of justice whenever it is probable that justice was, for any reason, miscarried. Another case. In the first circumstance, when the real has not been fully tried, the court may grant a new trial without considering whether the outcome would probably be different on retrial. The Wisconsin Supreme Court has established the new evidence could case blabbity 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 blabbity. As Sawinski and Romlow evidence is material and needs to be presented to a jury. The evidence refutes the state's theory that there were no third-party suspects and wanted to frame Mr. Avery. The jury never heard this evidence and heard evidence that has now been refuted by this new evidence. Next section, an evidentiary hearing is required. Good night, everybody who keeps leaving. I know it's late. It's 10:08 p.m. here. An evidentiary hearing is required. Quote, the circuit court must hold a hearing when the defendant has made a legally sufficient post-conviction motion and has the discretion to grant or deny an evidentiary hearing even when the post-conviction motion is legally insufficient, unquote. Talking about another case. Mr. Avery has the name of the witness, Mr. Sawinski, and the reason Mr. Sawinski is important. He provides evidence material and favorable to Mr. Avery, connecting Bobby to the Halbach murder as a third-party suspect and connecting Bobby to planting evidence to frame Mr. Avery. All corroborating materials have been identified, attached, and incorporated into this motion. Affidavits, law enforcement reports, trial testimony. These corroborating materials demonstrate that Bobby is a third-party Denny suspect because he had motive, opportunity, and is directly linked to Ms. Halbach's murder. Additionally, he is a Denny suspect who is directly linked to planting evidence to frame Mr. Avery by having access to key evidence of the crime because of his possession of the Halbach vehicle. Additionally, a new Brady violation has been identified as described previously. Similarly, Mr. Avery has sufficiently pled the name of the witness, Mr. Romlow, and the reason Mr. Romlow is important. He provided evidence, material, and favorable to Mr. Avery that refutes the state's theory and impeaches Bobby, that the Halbach vehicle never left the Avery property. Mr. Romlow describes a new Brady violation. A law enforcement report was never made of Mr. Romlow's conversation with a Manitowoc sheriff's deputy for 2005. Colborne? About Romlow spotting the RAV4 in a location away from the Avery property. If trial defense counsel had this information, they would have been able to refute the state's theory and impeach Bobby, the killer. The Sawinski and Romlow evidence would have been material and favorable to trial defense counsel because it would have undermined confidence in the verdict. Talking another case. Because of the suppression of this evidence, Mr. Avery did not receive a fair trial. Mr. Avery had a constitutionally guaranteed right to present a complete defense to the charges against him. Talking about another case. If this court is disinclined to believe the Sawinski or Romlow new evidence, the court must hold a hearing before making any credibility determinations. See all these other cases. Conclusion. Mr. Avery respectfully requests that this court grant him one of the following alternate remedies. 1. Order the state to file a response to the third motion for post-conviction relief and or grant an evidentiary hearing. 2. Grant this motion for post-conviction relief by ordering a new trial. 3. Grant the requested relief and grant any and all relief this court deems appropriate. I will add 4. Let him go home. Dated this 16th day of August 2022. Signed by Kathleen, and Stephen Richards is the Wisconsin local counsel. Okay, exhibits 1 and A2. So first exhibit is Wisconsin DOJ Division of Criminal Investigation. The interview with Brad Dassey, with Fassbender and Wiegert. Needed subjects. So Brad Dassey, Stephen Allen Sr., Avery, Brendan R. Dassey, Peter Dassey, dad, Teresa Halbach, and Barbara Ellen Yanda. Okay, so here's the report. On Tuesday, June 6, 2006, at 10:04 p.m., Special Agent Thomas J. Fassbender and Investigator Mark Wiegert of the Calumet County Sheriff's Department interviewed Brad A. Dassey. The investigators made contact with Dassey at his residence. The investigators identified themselves to Dassey, and Dassey agreed to answer questions, and he accompanied the investigators to Investigator Wiegert's vehicle where the interview took place. What is it with them doing interviews in the car? And oh my God, the one with Brendan where, what is that ticking the whole time that's going on in that? Is that the wipers or what? I don't remember, but just Dassey advised he is half brothers with Brendan Dassey and stated he confirmed that he had contacted the district attorney regarding Barbara Yanda, contacted him about her computer hard drive. Dassey advised that Yanda had contacted him and asked him if everything is gone from a hard drive when it is reformatted. Dassey advised that Yanda actually had someone else reformat it, but Dassey advised he did not know who did it. Dassey advised the other person reformatted her computer hard drive for something like $15, and she didn't think he know what he was doing. Dassey about a week after she had it reformatted. Dassey advised that Yanda told him about the investigators taking the computer approximately 1 week after they had taken the computer. Dassey advised that Yanda did not tell him what was on her computer. told Brendan about the letter he wrote just this past Sunday. Dassey advised that Yanda also saw the letter. Dassey provided a copy of the letter he wrote. In the letter, Dassey essentially expressed his sympathy to them for the loss of Teresa and wrote a prayer for them. In the letter, he wrote that he is not like Brendan, Yanda, or Steven Avery. Prior to concluding the interview, Special Agent provided Dassey with his business card. The interview was concluded at 2:18 p.m. At approximately 2:34 p.m., Special Agent Fassbender received a telephone call from Dassey. Dassey advised that he had spoken with Yanda to try and find out who reformatted her computer hard drive. Dassey advised she told him that Michael J. Cornelli gave her phone numbers. That was Blaine's boss, and Brendan had worked for him at one point too. Gave her phone numbers of individuals to contact, and that Cornelli knows who the individual was. Oh, now Cornelli is spelled wrong. Dassey and asked why he wanted to know. At approximately 3:01 p.m., Dassey again telephoned Fassbender. Dassey advised that he had contacted Cornelli, who said that he referred Yanda to Milwaukee PC. Oh my God, am I going to be able to read this? Oh, I don't care about Brad Dassey's letter. I guess I have to read it to you all because maybe somebody cares, but I think this is cheesy and was overstepping. Um, and a lot of this is like, Dear Lord, thou art in heaven. I can't read that. Grace of love, your hand of deliverance and peace. Please guide me in this prayer as I speak it to the hall box, Lord, because I am writing it through you, Almighty God. You are in control of the heavens. You are in control of our lives, and you are also in control of all that is evil in this world. Lord God, just let the Hallbox know that you are there for them. You won't let them down. You will bring them justice. You will bring them peace, O Lord. You will protect them all that is from all that is evil, Lord. Please place your hand upon their hearts, Lord, and soothe them. Soothe every nook and cranny in their heart, mind, body, and soul, Lord. I pray that you give them the peace and love they deserve, Lord. I pray that you keep their family together. I pray that you give them hope for the future, Lord, and they will something on and not forget about Teresa, but remember the awesome memories they've shared together as a family. I pray that you love this family like you've never loved before, Almighty God. In Jesus' name I pray, amen. I am very afraid to contact you, Hallbach family, due to the fact that I am indeed a Dassey through marriage. No, you're a Dassey through birth. Um, my real mom and my real dad were never married, so all my Dassey brothers are half brothers. Barb Yanda is my stepmom. Pete Dassey is my real dad. Then a whole chunk is blacked out. I just wanted to leave off with my sympathy I have for you and wanted blacked out. Something pray for you as well as my church family in Two Rivers. If you ever contact me with love, Brad Dassey, and then his email address. Next thing is examination of Brendan Dassey computer. These aren't the droids you're looking for. This is Brendan's computer. This is ineffective assistance of counsel. For to just believe when they're saying, oh, this is Brendan's computer. Oh, so of course there's not going to be anything of importance on there. You know, it's Brendan. Brendan can't harm a flea. So We don't care about Brendan's computer, so don't bother giving us what's on there. We don't care. Ineffective assistance of counsel. Why would you listen to Sweaty Sweat Sweat when he tells you that this isn't evidence you care about? All right, the report says on Friday, April 21, 2006, pursuant to search warrant, Special Agent Thomas J. Fassbender and Investigator Mark Wiegert of the Calumet Count Sheriff's Department seized a personal computer, CPU, and 12 from the residence of Barbara Yanda. On Saturday, April 22, Special Agent Fassbender items to Detective Mike Velli of Chute Police Department for forensics examination. On Thursday, May 11, 2006, Detective Veely returned said items to Special Agent Fassbender for subsequent return to Barbara Yanda. Special Agent Fassbender subsequently received from Detective Veely materials pertaining to his computer analysis of the hard drive and CDRs. This included numerous hard copy pages of instant messages, conversations from the hard drive, and a CD titled Dassey's Computer Final Report copy. The CD contained information on websites and images from the hard drive. Also provided by Detective Veely were 6 DVD a copy of the hard drive. I'm so freaking hungry. Special Agent Fassbender examined the items received and made the following observations. On February 28, 2006, there was an instant message conversation between an individual urging the screen name, I'm not saying that word, N for life, to believe to be Brendan Dassey, and an individual using the screen name. This is a long screen name. Pick up my hand, break my fingers, and when they feel numb, I'll let you know. I will scream until I'm out of breath. Danny Fabian, believed to be Danny Fabian. During said conversation, Fabian asked Dassey why detectives wanted to speak with Fabian's brother, and Dassey stated they just wanted to ask him why Dassey was losing weight. On February 28, 2006, there was an instant message. I gotta make it to fo going through hell, unquote. Believed to be Emily, a recent girlfriend of Dassey's. During said conversation, Emily asked, quote, do you think he is guilty, unquote. Dassey responded, quote, yeah, unquote. Emily then asked, quote, why do you, unquote. And Dassey, quote, I don't know enough to say, unquote. On March 4, 2006, there was an instant message conversation between an individual using Dassey's N-word for life, who identified themselves as, quote, Brendan's mom, and the person utilizing the screen name Emily, believed to be Emily. Ooh, good detective work. During said conversation, Emily advised that her mother doesn't want her to be involved with this, and she apologizes for that. Barbara Yanda responded, quote, he's not a bad person. His uncle is, unquote. On February 28, 2006, there was an instant message conversation between Dassey and an individual using the screen name bitches everywhere I look there is bitches. Julie, I okay. Believed to be Travis Fabian. Travis was Brendan's best friend. During said conversation, Dassey asked Fabian if he thought Steven was guilty, and Fabian responded, I don't know. Fabian then asked Dassey if he was guilty. Dassey responded, quote, yeah, Emily asked that to me, unquote. Fabian asked what Dassey said, and Dassey wrote, yeah. Fabian then repeated, quote, you said, yeah, he's guilty, unquote. On February 28, 2006, there was an instant message conversation between Dassey and an individual using the screen name Friendship is long lost love, and you wish you'll be able to overcome. What is with these freaking long, whatever? Believed to be Marie Avery. During the said conversation, Dassey asked Marie Avery if she thought Stephen was guilty, and Marie Avery responded, quote, yes, 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 finity, unquote. And wrote, quote, so do I now of the evidence they got, unquote. Something to remember about Marie Avery is she had sex with Stephen. She pursued a relationship with Stephen and she had sex with Stephen. And Marie was Earl's stepdaughter, no blood relation to Stephen. But this girl relationship with Stephen, but then continued even when Stephen is in prison, have contact with him. Um, In reviewing the images contained on the disc marked final report, Special Agent Fassbender made the following observations. Photographs of both Teresa Halbach and Steven Avery with an apparent date of April 18, 2006. There were numerous images of nudity, both male and female, to include pornography. The pornography included both heterosexual, homosexual, and bestiality. There were images depicting bondage as well as possible torture and pain. There were also text images with the name Emily. There were images depicting potential young females to include an infant defecating, injured and bloodied body, a bloody head injury, and a mutilated body. The disc received from Detective Veely, as well as the hard copy pages of instant message conversations, were maintained in Special Agent Fassbender's possession. Exhibit B, affidavit of Stephen Kirby. He, you're a, affiant is of legal majority and can truthfully and competently testify to the matters contained herein based upon my personal knowledge. Factual statements herein are true and correct, blah, 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 blah. Um, Chairman of Edward R. Kirby and Associates, a professional investigation firm located in Elmhurst, Illinois, which isn't far from me. On February 16, or he you don't need to know his background. If you want to know, you can read this. On February 16, 2022, he interviewed Michael Osmondson outside of his residence at blah, blah. Jim Kirby was also present and witnessed the interview and Osmondson's responses. He asked him if he ever helped Bobby Dassey push a car down the road leading to the Avery salvage yard. He replied, quote, I don't recall, unquote. Then asked him if by saying he didn't recall, if in fact he could have helped Brad Dassey or Brad Dassey. It's just a Dassey. Sorry, don't be thinking Brad Dassey's involved. Helped Dassey push a car down that road in November of 2005, but just forgot if he did it. He replied, quote, I don't remember, unquote. At the conclusion of the interview, he told him that wanted to be sure that he was not denying ever pushing a car with Dassey toward the Avery property, but that he just couldn't recall if he did or did not. Phone calls on October 31, 2005, to and from Bobby Dassey's phone number, he said he didn't recall making or receiving calls from Dassey that morning. When he was shown the printout of the message units, he said that the phone number was his number in 2005 and recognized the other number as Bobby Dassey's number. He stated that the early morning call could have been about hunting, but he didn't know for sure. When asked if he went hunting with Bobby that day, he said that he didn't. Oh, he remembers that. And as he took his brother trick or treating. When asked about the multiple calls to and from Bobby Dassey between 3:56 p.m. and 6:02 p.m. on 10/31/05 phone. Exhibit C, affidavit of James Kirby. Elmhurst, Illinois. Uh, He received a package in the mail from the Manitowoc County Sheriff's Office, which included 2 CDs and a letter dated April 12, 2018, addressed to me, signed by Larry Ledvina, Deputy Inspector, Manitowoc County Sheriff's Office, stating, quote, "We have received and reviewed your request for any non-911 recordings in your possession of incoming calls to the Manitowoc County Joint Dispatch Center from on November 3, 2005, and November 5, 2005. The dates in question are outside of our recording system storage. But in the time frame you requested recording for, copies were made of this time frame due to a different recording records request, and we therefore have some of the. They are date range of recordings. They are not broken down by date. 2 CDs enclosed that are responsive to your request. Phone number this, dated this, and phone number that, dated that. These CDs were delivered to the offices of Kathleen T. Zellner, subsequent to your affiant receiving them. On March 15, 2022, investigator Catherine McGovern of your affiant's office submitted 3 public records requested to the manager's office. The first request sought, and this is in italics, copies of any non-911 recordings of in your possession of incoming telephone calls to the Manitowoc County Sheriff's Joint Dispatch Center between the dates of November 3, 2005 and 12:01 a.m. through November 9 at 11:59 p.m. The second request sought copies of incoming and outgoing telephone call logs of the recorded Manitowoc Joint Dispatch calls between the dates of November 3, 2005, 12:01 a.m. through November 9, 2005, 11:59 p.m. that relate to the Teresa Hallbach investigation. Information should include date, time, and telephone numbers involved in the calls. The third request sought copies of audio recordings of incoming and outgoing calls and or radio dispatches between the dates of November 3, 2005, 12:01 p.m. through November 9, 11:59 p.m. that relate to the Teresa Hallbach investigation. On April 18, 2022, Catherine McGovern from your affiant's office received an email from Amanda Mathaby of the Manitowoc County Sheriff's Office regarding these requests. In this email, Amanda replied that she was updating Ms. McGovern regarding her request of copies of incoming, outgoing telephone call logs. She responded, "Do not exist." In reference to the request for copies of audio recordings of incoming and outgoing phone calls, she attached an invoice in the amount of $360 for these records. I have been talking for 3 hours now, not to mention all the talking I did the last 2 days before this. She requested your affiant's office remit payment so that she may begin working on copying these records. Your affiant's office subsequently paid the office for the requested amount. On May 3, 2022, your affiant's office received 35 CDs marked audio recordings from the Manitowoc County Sheriff's Office. On May 3, 2022, your affiant delivered the 35 CDs to the office of Kathleen T. A recording of a phone call from November 6, 2005 at 10:28 p.m., which was contained within one of the 35 CDs produced from your affiant's records request, was discovered by your affiant and the office of Kathleen T. Zellner. Your affiant listened to this call. Your affiant listened to 2 CDs produced to your affiant after your affiant's first public records request to the Manitowoc County Sheriff's Office in March 2018. The recording of the November 6, 2005 phone call in which Mr. Sawinski's voice was identified was not in the initial discs provided to your affiant following your affiant's March 20, 2018 public records request. Now we move on to my freaking God, what is that? I don't know what that is. What is that? Are those the list of the CDs or something? I don't know. Exhibit E, affidavit of Devin Novak. Uh, Around the time that it became known that Thomas Sawinski provided me with information of an unusual nature relating to the case. One morning after his paper route delivery, during the week that appeared, Mr. Sawinski told me the following event had occurred. He had been delivering papers and he saw two men pushing a car down a road. The men gave later, while watching the news, Mr. Sawinski saw Ms. Haubach's car and realized it was the same car that the men were pushing down a road. Thomas Sawinski reported that he told me about the incident to the Manitowoc County Sheriff's Department. I know that he called them because either I was there when he reported it or he reported making the call to me in the call. On August 6, 2022, I spoke to Stephen Kirby, an investigator on behalf of Steven Avery. Mr. Kirby asked me to listen to voicemail recording of a call between a woman named Carla from not that Carla, from Manitowoc County Sheriff's Department and a male calling in to speak to someone about the Teresa Halbach case. Mr. Kirby asked me if I recognized the voice of the male on the phone in the recorded call, and I recognized that the male in the call was Thomas Sawinski. Nothing has been promised or given to me in exchange for this affidavit. Exhibit A, transcript of the phone call. This is Carla. Can I help you? And then a male says, uh, I, I don't know if it's good information, bad information. Who do I talk to about this? The girl who is missing from Hilbert. MCSD says, I can have you speak with my shift commander. Can you hold on a moment? Male says, thank you. MCSD says, sure. MCSD says something that they couldn't transcribe and then says, I'm going to transfer you to the shift commander. You'll be talking with Sergeant, and they couldn't understand the word in the transcription. Okay. And the male says, thank you. And MCSD says, okay. And then the call is being transferred and then it's ringing. And then a sergeant says something that's unintelligible. And MCSD says, Scott, when I hang up, it's a man on the phone who thinks he has some maybe more leads. He wants to speak with somebody on the case. And the sergeant says, all right. And then that's where the call ends. Exhibit F, affidavit of Thomas Sawinski. I mistakenly stated in paragraph 7 of my prior affidavit filed with the appellate court that I contacted, quote, Avery's trial attorneys to inform them of what I saw, unquote. My prior affidavit is attached and incorporated herein as Exhibit A. After reviewing materials, my recollection was refreshed that I did not actually contact Mr. Avery's trial defense counsel and Mr. Strang. I realized after looking through my emails that rather than contacting Mr. Avery's trial attorneys, I had contacted the Innocence Project in New York and I never heard back. My email to Innocence Project is attached herein as Exhibit B. I met with investigator Stephen Kirby for Mr. Avery's post on August 6, 2022. He played a phone call recording to me, attached and blah, blah, blah. I recognized my voice on the phone call made to the Manitowoc Sheriff's Office, which I described in my prior affidavit. After listening to the first part of my call to the MSO, I refreshed my recollection that a woman answered the phone and that she transferred me to a male officer. I then provided the information stated in my prior affidavit. I mistakenly recalled in my prior affidavit, paragraph 6, that I had only spoken to a female officer. But after my recollection was refreshed by listening to a recording of the first part of my call, I realized that I also spoke to a male officer. Nothing has been promised or given to me in exchange for this affidavit. Exhibit A is his original affidavit. I'm not going to read you the original affidavit. We've heard that before, and I'm tired of talking. Next, here is a blacked out map of Avery Salvage Yard. Oh, so I'm going to guess it was marking where Sawinski was. Exhibit B is the Avery Sawinski. Um, on Thursday, January 7, 2018. Hello, my name is Thomas Sawinski. Newspapers to the Avery residents every day for years. I delivered papers at the time of the Hallbox situation, somewhere between October 31st, 2005. Not sure which day. I turned down Avery Road to deliver the paper as soon when I almost ran people pushing a dark colored small SUV down the road with absolutely no lights on. It was dark and I delivered as soon as possible each day so I could get home in time to get my son ready for school and drop him off. As I passed them, I realized I had stumbled onto something that seemed out of place. I spooked both of them tremendously. I drove down the dead end and put the paper in the tube and turned around to come back down the road. I knew I was in a shady situation, so I approached them with a good amount of speed to get around them fast. As I approached, the guy pushing from the drive and tried to stop me in the middle of the road. I went half in the ditch and just waved to calm the men into thinking I was oblivious to what was going on. I didn't see who the man on the passenger side, but the young man, maybe 18 or so, that tried to stop me was not Brendan Dassey. His build was thin and fit and about 5 feet 9 inches tall. Days later, after seeing the footage on TV of the RAV4 being found on the property, it clicked that it was probably the SUV I had seen that night. I called police and notified them. They didn't, it says SEMS, but it's supposed to be seem interested at all, and said thanks for the info. Never asked me to fill out a report or even ask for my name or phone number. At the time, I just figured they had enough evidence and were not concerned with my information. After seeing the documentary on I decided that someone other than Manitowoc County officials needed to hear this. They were pushing in the direction. I feel obligated to share this now that I know some of the circumstances involving the way Manitowoc handled the case. Exhibit C, transcript of phone call that I've already read. Group G, after Dean Strang. I have reviewed Mr. Buting's affidavit of August 11, 2022. My recollection and understanding comports with his that he addresses in that affidavit. Within the scope of my personal knowledge, I agree with and confirm this affidavit, dated this 12th day of August 20. Next is affidavit of Dean Strang. I have reviewed Mr. Buting's affidavit on saying all the same thing that I just read. Now is affidavit of Buting. Mr. Strang and I repeatedly requested notice of all exculpatory or potentially exculpatory information and otherwise discoverable from the prosecutors and the Manitowoc County Sheriff's Department. This included reports of any tips from citizens and, quote, audio tape copies of dispatch, all other communications relevant to law enforcement operations involved in the search for and investigation of Teresa Halbach's disappearance for the period of November 3, 2005 through November 12, 2005, unquote. An example is my July 24, 2006 letter attached as Exhibit A to this affidavit. I received a CD-ROM that purported to contain all Manitowoc County Sheriff's Department dispatch calls related to the investigation, covering the period November 3, 2005 through November 12, 2005. That CD-ROM was at some point turned over to Mr. Avery's successor counsel. I've recently reviewed the handwriting on a copy of that CD-ROM, which I recognize my handwriting. I am informed and based on my own recollection that this copy of the CD-ROM came from my files on Mr. Avery's case. I recognize my handwritten note on the CD-ROM to a dispatcher from then Sergeant Andrew Colborne requesting information on a license plate of Teresa Halbach, that he was looking at the car. That CD-ROM copy and my handwriting on it confirm my recollection that I listened to all of the calls recorded on that CD-ROM. I have recently re-listened to all of the recordings on that CD-ROM that I received during my representation of Mr. Avery, and I compared it to another CD-ROM that Mr. Avery's current counsel provided to me. Upon information and belief, she received this CD-ROM as a response to a recent open records request. On the newly disclosed CD-ROM, there is an additional call from a citizen tipster that was not included in the audio recordings that I received during Mr. Avery's representation. I have been informed that the caller on this recording is an individual later identified as Thomas Sawinski. The Avery defense team was not given the audio of his call, his identity as a potential witness, or other information we could have investigated and used at trial. The newly received CD-ROM that current counsel for Mr. Avery has shared with us, which includes a call purported to be from Mr. Sawinski, indicates that the caller was transferred to investigator Sergeant Scott Senglob. By inference, Sergeant Senglob spoke to the caller, shows that the dispatcher connected the caller to him. Neither I nor Mr. Avery's defense team ever was given a recording, a report, notes, or any other notice of a conversation between Thomas Sawinski and Sergeant Scott Senglob of the Manitowoc County Sheriff's Department. At the time we were requesting discovery and disclosure of exculpatory information, Mr. Strang and I were using a private investigator, Conrad O. Pete Bates. We had Mr. Strang and I known before Mr. Avery's trial about any information that a person had reported two men pushing an SUV on the Avery property in the darkness before the reported discovery of Ms. Halbach's Toyota RAV4 SUV on the Avery salvage yard property, we would have pursued that information diligently with Mr. Bates and otherwise. Had Mr. Strang and I received or known before Mr. Avery's trial about Thomas Sawinski's telephone call with the dispatcher, which shows that she transferred that call to Sergeant Scott Senglob, we would have made a specific request for further information about the substance of that call from Sergeant Senglob. Although the new CD-ROM reveals that Thomas Sawinski indeed did call the dispatcher during the time frame of the CD-ROM given to Mr. Avery's trial counsel, Mr. Sawinski's call was not included on the pretrial discovery CD-ROM. As to the call from Andrew Colborne described in paragraph 3 above, neither the prosecution, the Manitowoc, disclosed to me or the defense team the date and time at which the call was made. The other recorded calls that were disclosed to us, the audio record of that call from Andrew Colborne had no timestamp or other documentation of the time of the call when it was disclosed to me and the defense team for Mr. Avery. We thus had no way to challenge or disprove any claim that Mr. Colborne might make about the specific timing of that call, dated this 12th day of August 2012 or 2012, 2022. Um, and so now this is a fax. Special Prosecutor Kenneth Kratz regarding State of Wisconsin versus Steven Avery, dated August 7th, 2006. Oh, so it's two Kratz. I'm writing to follow up on some discovery issues in this matter. There are a number of items we do not have yet, and as I have gone through the discovery already provided, I tried to make note of them. Most are referred to in discovery, but some are independent of that. By copy of this letter, I am also notifying Investigator Will's convenience, as I assume he will assist you in responding to your requests, as well as Norm Gahn, since some of my requests concern crime lab DNA testing. Please locate and produce the following: 1. Audio tape copies of dispatch of all other communications relevant operations involved in the search for an investigation of Teresa Halbach's disappearance for the period of November 3, 2005 through November 12, 2005. This would include anything recorded on any type of media by law enforcement or public safety agent. This should include, but is not limited to, radio communications, both voice and data, routinely recorded by any agency, or any and all frequencies available to law enforcement or public safety units assigned to the search and or investigation. It should also include data or message transmission agency pertinent to the search and investigation activities via computer enforcement or public safety agency and civilian assets such as aircraft or ground vehicles involved in the search and investigation activities. I made a similar, though perhaps not as detailed, request about 1 month ago, and I believe Mark Wiegert spoke to Dean, and he is working on this already. A listing of all Calumet and Manitowoc County Sheriff Department personnel involved in this investigation, which includes their officer, personnel, or squad number. This is so we can decipher who did what in reports that just refer to, for some, or for in 801 did arrive and ... unquote. Most reports we have received are easy to decipher, but some, like the log-in sheets from officers checking in and out, are prepared strictly by reference to a number rather than a name. Crime Lab bench notes for all analysts who have or will be preparing reports. We received only part of Sherry Big Hair Colhane's notes so far, from ballistics, identification, blood pattern analysis, and others in the crime lab who have prepared reports. Also, Sherry Colhane's last submission of bench notes only goes to early April. See her correspondence to you dates April 12, 2006. She has obviously done many examinations since then and must have generated many more pages in her file. Crime Lab, Madison office, error logs, and other records of contamination of evidence by analysts' own DNA and other types of contamination revealed by the lab's testing process, and proof of any and all corrective action taken by the lab detected. Please provide such records for the time period of January 1, 2004 to the present date. Copies of the electronic computer data files from DNA testing in this case, as my expert needs to see the raw data himself. He should be copied onto write only. Specifically, we request for blah, 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 the following. Blah, 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 all these different files. Of the crime lab's proficiency data, my glasses are so hurting my nose now. Reports of the crime lab's proficiency tests are of any corrective action taken whenever proficiency testing discrepancies are detected for the last 5-year period to date. Testing in records shall include those indicated in the DNA Advisory Board Quality Assurance Standards for Forensic DNA Testing Laboratories. Another copy of this audio tape interview of Brendan Dassey from February 27, 2006. The CD previously provided of this recording cannot be read by any computer in Dean's or my offices, so I assume it was just a defective burn when discovered at the Avery salvage yard. Copies of any and all video recordings made of the interior of Steven Avery's trailer, garage, or vehicle. I believe the reports reference Sergeant Tyson making such a recording. Copies of any and all video recordings of the burn barrels as well as the burn pit before it was altered by investigators digging. Doesn't exist. Copies other video recordings made at the Avery salvage property, with the exception of an 8mm recording of a view of the pit from the Redant property and an 8mm recording of the conveyor area. To date, those are the only video recordings I think we have received concerning the Avery property. Copies of Orville Jacobs' phone and visiting audio recordings and visitation logs for the entire length of time when he was housed together with Steve. Copies of all unedited flyover videos recorded from aerial searches on November 4, 2005 and November 6, 2005. We currently have a spliced copy of a DVD, which is obviously from several different dates, times, or aircraft with no separation or designation as to their date and time. I assume there must be a master copy of the complete videos. Crime Lab field response team reports from Ertl and Zeng, or other Crime Lab personnel, which describe their involvement at the Avery property and the transfer of the RAV4 from the Avery property to whatever location it was next taken. Please also include reports which explain where and under what conditions the RAV4 was kept up to the point Sherry Culhane began her examination on November. Note that Calumet County Sheriff's Department report numbers, blah, blah, refer to detailed measurements and diagrams being taken of Steven Avery's residence and garage for possible court diagrams of 3D representations. If those are available, exhibits group A1 and A2. And that's what we already know. Not reading that again. It's the same stupid email he sent the family. This is the Brendan Dassey again. And the whole then, read all that already. Exhibit B, affidavit of Stephen Kirby, where he talked to Mike Osmondson. Exhibit C, James Kirby, talking about the CDs that we've already read. Exhibit D is that same whatever that log thing is that we've already seen. E is the affidavit of Devin Novak that we've already seen. Exhibit A is the transcript of the phone call we've already seen. F is affidavit of Thomas Sawinski we already read. Exhibit A is his original, Sawinski's original affidavit. It's a picture of the salvage yard. Exhibit B that Sawinski we've read. Exhibit C, transcript of that phone call again. Exhibits group G, affidavit of Dean Strang, and now Buting. Why is this stuff all in here a second time? Here's the email to Kratz that we are just read. That's everything. We're done. 3.5 hours. So, to summarize, and I'll probably make a post on Steven Avery project, but not today. It'll be done tomorrow. To summarize, what we have now is there is proof that Sawinski called to say, I saw people pushing the RAV4. There's proof of that. So, Steven absolutely, at the very least, should be getting what is the very least an evidentiary hearing? To then evidentiary hearing say he should get a new trial? I mean, we all know he should just be let out and go home, and now Wisconsin be called Avery land. We know that. Flowers is going to deny it. We know that too. It's such crap. So, that's that. We have it posted on Steven Avery Project where you can go read it for yourself. I know. One thing before I go, I know we've talked about this, so so this is my book that I now have completely edited. I've now edited most of it, so it's still going to be some of my crappy grammar. I'm just waiting for my husband to create my cover. And now I'm going to end up writing another chapter to summarize this next filing. So, but my book is about me. Um um my journey with this case. So, and then we'll be selling it on Amazon because that's what I am told is the easiest way for me to go about it. And so, yeah, it's not on there yet because I'm waiting for my husband to he printed me this copy because somebody started editing it for me, and they wanted a printed copy, not an electronic copy, where they literally then let me get it. They red penned it, like a teacher, and edit it. So now, I mean, and here's pictures I took that are in there. So now I'll write a chapter then summarizing this latest file. I also post some kind of summary of the filing, but it'll get done tomorrow. I'm so freaking exhausted now. But hey Jen. But thank you everybody who joined me when we started this video 3 hours and 35 minutes ago. Thank you to people who are going to be watching it now after the fact. I don't know when I will be live next. I have not one, but 2 paid jobs right now in politics. I am a campaign manager for somebody running for reelection. That's on is a county board person, and then I am a relational field organizer for my state senator. So I've got a lot of politic and stuff that I have to do, and through the November 8th election, so I can't regularly be online and do lives. I am doing all this politics stuff. But I will post a summary on Steven Avery Project Facebook tomorrow, a write-up of what the important takeaways are from this filing and what my thoughts are on it. I will write a chapter in my book. The state will be responding to this. Somebody smarter than me tell me how long the state will have to respond. Oh, I have makeup on and I just rubbed my eyes. I like never wear makeup. Um um is it 30 days, 60 days? When the you're lucky when Kathleen files, she posts it on her website, and I was lucky that she emailed me the copy that I just read. When the state does it, um, we don't readily get a copy. So a lot of times I contact the clerk and they make me pay to I have to pay per page. Like back in the day when you have to like you're printing it and like they're sending, mailing me a hard copy or not. It's just an electronic thing, but I still have to pay per page for however much it is. So we'll just be on the lookout for when the state rebuts it. If you see it before you see it linked to on Steven Avery Project, please send us a message on Facebook, or you can email me at either official Steven Avery Project at gmail.com or justicewithjax at gmail.com, whichever is easier for you to remember. And let us know, or private message me personally, because like Maz messaged me today to say, it's on Kathleen Zellner's website, so thank you, Maz. um so let us know, and if you find it somewhere, let us know so we can get it posted. And then when I am able to, depending on my work, so whether or not we're able to find it online or I have to pay the clerk, and me to a website online, and so then I can just pay it with my debit card, and then they email it to me almost right away. um so when the state responds, we'll read that and discuss that, and then when Kathleen responds to that, and then when the judge responds, so as soon as it's out there, we'll go live as my schedule allows. But all right, I really got to go. It is now 11:08 p.m. my time. I have not had dinner yet. I was at all these political events and drove for like 4 hours. I'm out. I want to wash my face. See, my face is all sweaty and yucky. Um I'm gonna go wash my face. I'm gonna go eat something. I'm gonna go put on some pajamas. So thank you, everybody. As always, investigation continues. Bye, everybody.